Good morning, everyone, and welcome to the Catholic University of America. This is the 2012 symposium of our Journal of Contemporary Health, Law, and Policy. And of course, I emphasize contemporary because they are always very much so right on target with respect to the important issues that we need to be concerned about with respect to health law and health policy as well. The title for today's program, Ushering in Accountable Care, Progress and Future under the Affordable Care Act. As we all know, there's a great deal of conversation about this, a great deal of debate about the administration's Patient Protection and Affordable Care Act. And regardless of where you stand on the various provisions of the law and its policy, it is extremely important because it will represent a very significant change in how most Americans will receive health care and health insurance in the future. One of the law's key provisions is the creation of the Accountable Care Organizations, which has been defined by the Centers of Medicare and Medicaid Services as an organization of health care providers that agrees to be accountable for the quality, cost, and overall care of Medicare beneficiaries. Now, under this new law, the ACOs will represent a different way of doing things. And of course, that is going to be the focus of our conversation today. I want to thank in advance the very wonderful and highly accomplished panelists that will be a part of the program today. They will bring an amazing level of experience to this conversation. And I'd like to acknowledge one of the other panelists. It's always a privilege to be able to claim our own. Mr. Tom Scully is a graduate of our law school, and he is now senior counsel with Alston Bird. I don't think he's arrived yet, but we are very delighted that he is here. He served as the administrator of the Centers for Medicare and Medicaid Services from 2001 to 2004. And of course, none of this would be possible without the very hard work of our students, our editorial board, and our staff members who have done an extraordinary job this year in putting this program together. And they are a continuing part of the great legacy of this journal, which started in 1984, and we're very proud of all of the work that they have done. Again, on behalf of our community, I want to thank all of you for being a part of today's program, and I know that the students will look forward to having your conversation be a part of this rich opportunity to consider the issues before us today. I want to thank all of you again for being here, and now I'm going to turn the program over to the folks who are definitely in charge always, and their leader is the editor-in-chief of the journal, Mr. DeCastro.
Thank you, Dean Miles. It's always a great pleasure to see you at these events. We're very fortunate to have a dean that is so dedicated to this law school and to these organizations under it. Good morning. My name is Philip DeCastro. I am the editor-in-chief of the Journal of Contemporary Health Law and Policy. It's so great to see so many of you here. I'd like to especially extend a warm hand of welcome to the administrative law judges that are here today, the practitioners from the public and private sector, and the faculty that are also here. So today we are very excited to be presenting on this very timely and relevant topic of ACOs. And I'd also like to recognize our symposium editors, Tara Beach and Evan Hom, who have worked tirelessly and have shown such great dedication to put this event forward. Our executive editor, Virginia Fuller, also helped a great deal. I'd like to thank her as well. And Joan Verassi and the Office of Student Life have done a great job in setting all of this up for us. So I'd also like to point out that we will be publishing 3 articles related to ACOs in our forthcoming issue, which would be Volume 28, Issue 2. One of the lead articles is by Edward Correa. Its title will be Aligning Physician Decision-Making with the Goals of Healthcare Organizations. Are there any lessons from law firms? Two of our student pieces have also been selected, and they relate to ACOs. The first one is by Patricia Bruns, who is over there, right there, if you want to see. Her title would be An Antitrust Analysis of Accountable Care Organizations, Potential Abuses from Allowing Reduced Scrutiny under the Affordable Care Act. The second article, student article, is by Peter Feiss, who is right there. His title is Seeking Accountability, Prognosis for Synergy Between Accountable Care Organizations and Bundled Payments in Medicare. If you would like an advance copy of this journal, you can sign up at our registration table, and we'll mail you the copy directly. And so, just real quick, the refreshments are outside. Feel free to continue to get them as the symposium goes on, and we will break for lunch at around 11:30, I believe. So I'll turn it over now to Evan Hom, who is one of our Masters of Ceremonies today for the morning session. Thank you.
Thanks very much, Phil, and thank you to the whole journal, and particularly to my co-symposium editor, Tara Beach. Welcome to our diverse group of audience members. We're very excited that you could join us for today's event. I want to start by thanking our distinguished presenters. We are incredibly fortunate to have such a high level of expertise represented by the panel, and it means a lot to the entire journal that they could take the time from their busy schedule and prepare for and be at the symposium today. This morning, for the morning session, we have three presenters. Each has a limited 45-minute slot in which to present, the last portion of which will be dedicated to questions and answers. If you have a question, please raise your hand and the presenter will call on people. And I'd like to remind the presenters to please repeat the question before answering so that we can hear it on the recording, which will be available on the school website if you cannot stay for the entire event. We'll need to be cutting things off roughly at the end of those 45 minutes, but many of the presenters will be here during the lunch break and after the event, and you may be able to bring any unasked questions to them personally at that time if they have time to stay and answer them. So first off, we are proud to have on hand one of the top resources on accountable care in the entire nation, Douglas Hastings. Mr. Hastings is managing partner and chair of the board of directors of Epstein, Becker, and Green here in Washington, D.C., and he also spends substantial time in the New York offices. He is also a past president of the American Health Lawyers Association. Mr. Hastings was Order of the Coif at University of Virginia Law School and received his undergraduate degree from Duke University. Mr. Hastings will be providing an overview of why we are here today, the problems accountable care organizations are designed to solve. Then Mr. Hastings will talk about the ACO final rule, and in particular the core infrastructural and formation requirements under the Medicare Shared Savings Program, which is at the heart of the Affordable Care Act's attempt to usher in accountable care. So without further ado, Mr. Hastings.
Thank you, Evan, for that kind introduction. Good morning, everybody. It's a very distinguished audience. I'm honored to be here to talk about accountable care organizations in the context in which they arose and direction they're heading. A very important topic in my view, and I think it's great that you are addressing it in this conversation. I think we have entered with this year, now only a month or so old, a new chapter in this process. And I thought I'd start by just reading a couple of sentences I wrote for a national journal on accountable care, asked to comment on the tenure of Don Berwick, who was the head of CMS. We have Tom Scully coming later, but the head of CMS during this period of initial implementation of the Affordable Care Act. But I think it is an overlay for my remarks this morning. So my comments on his tenure were that Don Berwick's tenure at CMS was notable in several key ways. He brought to national scale a vision of healthcare that is about being healthy, not just about being sick or injured, and tied science and measurement, as well as patient satisfaction, to payment. He inspired and coordinated an unprecedented level of intergovernmental collaboration among CMS, the Office of Inspector General at HHS, the Federal Trade Commission, the Department of Justice, and the Internal Revenue Service in considering how to regulate ACOs to both promote good and prevent harm. And he oversaw not only the development of the Center for Medicare and Medicaid Innovation, but also the completion of the Medicare Shared Savings Program Final Rule, which included a very robust and helpful public-private dialogue on what ACOs should be. And so with Dr. Berwick's departure from CMS, a chapter in payment and delivery reform and coordinated care has ended. We now begin the true implementation chapter with very much at stake. And that is where I think we are, and that's kind of the context for my remarks. So I talk in the title here about value-based payment and accountable care and the ACO final rule. This healthcare evolves. There are chapters, but it's an evolution. For the last decade leading up to the Affordable Care Act, there was an ongoing robust and increasingly robust dialogue about the healthcare system and how, while it did many wonderful things, it had fundamental challenges. Care was too fragmented, practices were often uneven and unsafe, and the costs were absolutely unsustainable. And you can see many other presentations about the cost curve in healthcare. You've heard about that in the context of the budget debates. But there's really a consensus that something needed to be done. What would that be? Well, a lot of the blame began to be put on in this dialogue, in academia, in the policy community, on the fact that payment was transactional. It was all individual payments for fee-for-service delivery, and that ultimately, while, again, our system does many wonderful things, that did not produce a level of cost efficiency and quality and coordinated care that we needed at this point in going forward. In 2001, the Institute of Medicine, in a monumental study you ought to read if you haven't, called Crossing the Quality Chasm, defined healthcare quality as care that is, yes, safe, but also effective, efficient, patient-centered, timely, and equitable. That definition and those words are the intellectual underpinning of about half of the Affordable Care Act, the half that deals with payment and delivery reform, as opposed to the half, more or less, that deals with increased access and insurance coverage. And by the way, it's that access and insurance coverage half that is what's most controversial. It's really what the Supreme Court is looking at in connection with the individual mandate. There really has not been much debate over the importance of driving toward a more coordinated care system and payment mechanisms that promote more coordinated care. So what is the solution that has evolved in the thinking about where the healthcare system should head, particularly with regard to payment and delivery? Well, it's this big idea of accountable care. There are other names that people use, coordinated care and so forth, but basically it suggests that what we need is care that is better coordinated, more transparent to the consumer, using evidence-based measures to achieve this three-part goal: better outcomes, greater patient satisfaction, and improved cost efficiency. That's accountable care. Accountable care organizations, whether you're talking about what has been created, which I'm mainly going to talk about in Section 3022 of the Affordable Care Act, or in commercial market variations that are blossoming every day. Accountable care organization is, at least in theory, a provider-based organization comprised of multiple providers who come together with a level of clinical integration, meaning they're coordinating their care sufficient to deliver accountable care. The view is that both payment and delivery in both the public sector and the private sector need to change in a really fairly balanced and aligned way in order to achieve that, and there's widespread agreement on that direction. The question is the pace and the exact method of the transition. It's not my topic to talk about the political debate around the Affordable Care Act or the Supreme Court decision that's coming up or what might happen in the 2012 elections. But my view is that these ideas have consensus, even if the parties are not commonly going to talk about where they have bipartisan agreement right now. You can see just in the recent weeks some hearings held by Republican-led committees on the Hill dealing with the future of physician payment and the need to reform that, in which these very same ideas are being discussed, and there's testimony, and the Republicans are agreeing that this is the right way to go. So my own view is, regardless of what happens in the Supreme Court decision and the 2012 elections, these ideas, and probably that component of the Affordable Care Act, will remain in place, and they are being moved forward in the half of the world of payment that doesn't come from government in any event, and I think they will continue to move forward there and in some form through Medicare and Medicaid. This is not a new chart, but it also helps frame what accountable care organizations are about and really doing. I talk about the fact that accountable care and accountable care organizations relate to payment and delivery reform to improve our healthcare system. Okay, so this chart from the Commonwealth Fund suggests in the vertical axis that payment needs to change, and it moves from today's fee-for-service payments at the bottom through phases of change in payment away from pure individual fee-for-service. Bundled payments are actually just sort of shared savings, which is what the Medicare Shared Savings Program fundamentally starts with, all the way up to forms of global payment or capitation, a word we heard a lot in the 90s. The horizontal axis talks about the continuum of organization, the integration of the delivery system as payment changes, moving from totally independent physicians, hospitals, and other providers toward various forms of more integrated systems, all the way over to fully integrated systems. And the notion around accountable care organization, the Affordable Care Act, the Shared Savings Program, the final rule, and commercial market analogs is, how do you define the nature of that provider entity? What should it fundamentally have to do, and how should it be structured? And how do you pay it in order to promote better outcomes, greater patient satisfaction, and cost efficiency? It's complex, it's uncertain, we're testing, we're experimenting, we're moving, but this frames that question. Do you start here, somewhere in the middle, somewhere up at the upper right with, you know, the Mayo Clinics and the Geisingers of the world, or a bunch of independent physicians in a rural area who have formed an IPA, and the notion that there has to be reasonable balance, so it's not going to work. We saw this in the 90s, to have startup organizations that really are not effectively coordinated. They're just beginning to coordinate, take a capitation. They're not going to be able to manage it very well. On the other hand, very sophisticated integrated organizations are not particularly interested in a mere shared savings arrangement. We can get a little bit into more of that dialogue, but much of the debate around the Medicare Shared Savings Program and its implementation and the way to write the final rule was about where to make put the minimum set of requirements for an ACL, at least for the Medicare program, knowing that the commercial market is going to look at how Medicare would define an ACL and probably adopt a lot of the same ideas, where to put the minimum requirement. Way down here to encourage more ACO formation, but take the risk that they won't do enough fast enough, or way up there where there's going to be very few ACOs, and maybe they'll be able to accomplish more, but it's less brought to scale around the country. And as Tom Scully is going to talk about pioneer ACOs, that's sort of more to the upper right. And I'll get into how CMS went about making that decision, but that's sort of the basic framework of the choices. As I said earlier, it's not as if these ideas around payment change and integration are new. There was a whole round of this in the 90s and ongoing through the last decade. But there are reasons to think it's more likely that this will take now, principal among them the fact that we have a much clearer idea of how we can use evidence and evidence-based medicine to show how care should actually be delivered in a consistent fashion. You hear the expression, the right care at the right time, every time. That's part of that notion. And there's so much we've learned from past experience. And by the way, I'm not going to go through all the content in all these slides, so They're available to you if you'd like them. Evan has a copy, and you're welcome to have them. There are pitfalls. It's not certain this will be successful. I guess I get asked all the time, is this going to work? Well, I think it has the potential to work. We're going through a period of testing, but there are some reasons it could fail. If the Medicare ACO program, which is the focus of this morning, fails miserably, that would be a threat. If patients are left out of the equation, if it feels too much like managed care of the 90s, many of you will remember the pushback against a similar kind of idea of managed care. And so with ACOs, there's an attempt to do some of the same things, change payment to incent providers and patients to collaborate better and to manage care, but to do it in a way that maintains greater freedom of choice. And a lot of people are skeptical that that will happen, and certainly if cost savings are not realized fast enough, and there's even way more pressure on achieving cost savings than there was 5 years ago as this was being discussed. If they're not realized fast enough, even if these ideas show some promise, the question is there going to be the social and congressional patience to wait for them to mature? And that all remains to be seen. But I think I'm with a lot of others. It's an important opportunity for the private sector and the almost universally private healthcare delivery system to itself change in a way that creates greater quality and greater cost efficiency. The failure to do that will lead probably to more draconian types of price constraints that probably aren't, in my opinion, in anybody's best interest. So we will see. The question inherent in this program this morning is, are we making progress with these ideas? And I think we are, although, we are a diverse country. The healthcare system is, as often said, local. And so as we test general ideas and attempt to bring them to scale, we won't see uniform results, which is fine. And again, there's a question of the patience to make progress. But I believe with the evolution of the Medicare's ACO programs, including the Medicare Shared Savings Program, and the proliferation that's begun in the commercial market, it's fair to say we're making real progress. But, as I said at the start, I think with the start of this year, that is going to need to move from progress in acceptance and progress in starting up some efforts to real progress in impacting quality and cost. There are those who would say it's more likely that the large insurers and large employers who are very interested in these ideas and are adopting them will have more impact than Medicare. That's okay. 50% more or less of payment is government versus private. But clearly, even if you believe the private sector will move quicker or more effectively, what the Medicare program does in this regard is critical. It does affect half of the payment, and there's no question that commercial payers model a lot of what they do off the way the Medicare program addresses payment. That's historically been true, and the payers, I've been on a number of private payer, provider work groups. The large payers will all say we definitely watch the way Medicare structures its programs and adopt, the ideas from it that we like. Understand also, as I will then move into a little more detail on the Medicare Shared Savings Program, it is just one program out of scores of programs that were rolled out in the Affordable Care Act that relate to accountable care, relate to value-based payment. So it wouldn't be a correct view, in my opinion, to say all the eggs of this movement toward accountable care, toward quality and cost efficiency should be viewed as being in the Medicare Shared Savings Program basket. And I'm not going to go through all these programs, but the next several slides cover a whole bunch of different things that are rolling out over the next, have already started to roll out, or are rolling out over the next 3 to 4 years related to Medicare payment and ways to better achieve more cost-efficient, more high-quality care. Among them, you will see community-based programs that are primary care and medical home-oriented, A lot of the states are also doing that through the Medicaid program. You'll also see bundled payment pilots, again, accountable care type programs, and the Medicare ACO program basically relate to an idea in which an organization, an ACO, through some agreed upon payment method, takes responsibility for the care of a whole population. In the Medicare rule, it's a minimum of 5,000, for example. Not all of these ideas under value-based payment require that. A bundled payment is a arguably smaller bite at this apple, taking a particular service or episode of care, but coordinating the care of all the professionals, hospital physician, nurses, and others around that particular episode of care, and using a payment methodology which would incent the coordination among that group. There's also plans for value-based payment, which simply means it's still fee-for-service payment. Everybody is an individual provider providing care for Medicare, but all reimbursement is going to be reduced, but those that achieve value, hit quality measures, and otherwise practice in a more coordinated way based on those measures will get more, so that they won't lose, or they'll even do better than everybody else who is pushed down. So again, I could go on into more detail about some of these programs, and I have a couple of slides on what's already rolled out this year, but it's to, again, make the point that the Medicare Shared Savings Program is one piece of a larger puzzle. And probably the things you'll have heard about most as a component of that puzzle, besides ACOs, are bundled payments, which is now a demonstration under the Center for Medicaid and Medicare and Medicaid Innovation, which is part of CMS. It's also going to become a national pilot program in 2013. I've mentioned the value-based purchasing program, which now applies to hospitals, but there are provisions in the law that are going to apply it to long-term care companies and to physicians over time. And then there also is, which I won't say much more about because Tom's going to cover it, the Pioneer ACO program. And let me just explain that for a second. One of the provisions that kicked in 2011 was the formation of a new unit within CMS called the Center for Medicare and Medicaid Innovation. It's one of the few components of the Affordable Care Act that had new money, $10 billion over 10 years, to spend on promoting experimentation and testing of these broader ideas of coordinated care and accountable care. Among the things they're testing, and there's a broad range, are ACOs. You may say, wait a minute, how does that work? There's this other Medicare ACO program. Yes, but what CMS overall decided to do was to launch before the statutorily required Medicare Shared Savings Program its own experiment, because it's an innovation center with more advanced ACOs that are ready to take capitation or some sort of global fee. And there was skepticism, is anybody going to apply for this? And some of the big names, Mayo Clinic, Geisinger, Cleveland Clinic, said, we're not going to do it. Something like 80 organizations applied for the Pioneer, and 32 were selected, and they're kind of toward the upper right in that chart I was showing you. Again, that's all I'm going to say because Tom will cover it in more detail. But all of that is going on while the Medicare Shared Savings Program, which is the third point on this chart, is being implemented. And they will all be evaluated together over these next several years, including, not unimportantly, some penalties for hospitals that have too many readmissions or too many hospital-acquired infections. Again, measuring outcomes. All of that will be rolled out by 2014, which, if the Affordable Care Act isn't changed, would be the principal starting point for the broader coverage and access provisions. Whether the improvement brought through these programs between now and 2014, 2015 is enough to keep moving in that direction and not change it in a material way, and depending on what happens in the commercial market, remains to be seen. So in 2010, first half of 2010, the Affordable Care Act passed, and it included, thousands of pages of provisions. As I said, about half of it is access to care and coverage. That's been the most hotly debated politically. The other half, more or less, had to do with payment and delivery changes. And within that, The 3000 section, if you want to go back and read the Act, pretty much contained all of these provisions regarding accountable care. Now, you know that it was an interesting history how that bill got passed, and so it didn't go through reconciliation, and so some of the provisions are less complete than ultimately they would have been. But actually, Section 3022 of all of these accountable care provisions was one of the most complete in the statute itself. Most of these ideas around payment and delivery reform that came out of the Act and are being tested are pilots and demonstrations. They're not statutory, done, we're doing this permanently unless changed or repealed. But the Medicare Shared Savings Program, which is the Medicare ACO program, was in the statute, and it said, here are the statute, here are the kind of organizations that can be ACOs, here's basically what they have to do, and here are some ways you need to think about paying them. It starts out being shared savings, which I'll talk about more, but the statute said you can move up that line toward global fees and capitations if you, CMS, or the Secretary so choose. So CMS was tasked, therefore, with writing regulations off a pretty specific statute. And if you remember this, if you were following this at all, there was this explosion of excitement around ACOs. One of these things where there's so much following that goes on in our industry, and while it wasn't a brand new idea, labeling it accountable care organization, what is this? I want to have one. There were some funny YouTube videos about hospital CEOs saying, give me one of those things, you know. And then CMS wrote its first draft regulation, published in March of 11. I don't know how many of you were following it. It was like a massive, all the air being let out of a huge balloon. The response was way negative. Oh my goodness, we have this great idea, and look at what CMS has done. They've just written this heavy-handed, impossible thing. We don't understand it, you know, and we can't implement, never mind ACOs. I'm exaggerating, but not that much. So a lengthy period of comment perpetuated. And this is part of what Berwick and CMS did very well. They said, okay, we hear you, but you know, this isn't simple. And I think some of that negativity was an overreaction to something that is not easy, to figure out where on that diagonal line to start these things, what they have to be required to do. So CMS engaged in a dialogue. There were 1,300 comments received on that rule. In the middle of the time they were considering the final rule, they did the outreach through CMMI for the Pioneer model, and people saw that that was more flexible. And so the pendulum started to swing back a little bit. And then on October 20th, the final rule was published. And overwhelmingly, the policy commentary in the industry said, wow, these are vastly improved. I think some of the original negative reaction was an overreaction, but clearly in the final rule, CMS went a long way. If you want to read the preamble, and I think I have a slide in here that talks about that, if you're really interested in this, and maybe some of you have done that, read the preamble to the final rule. They literally lay out the whole history of accountable care thinking, how we got, the Institute of Medicine, et cetera, how we got to here. Why they wrote the reg the way they wrote it initially. I mean, if you like administrative law, I just think this is good stuff. Why they wrote it the way they did initially. All the comments they got, you know, divided in logical segments of the way they were thinking through this rule, and why they chose, and what options there would be based on those comments, and why they chose the option they did. It's the best summary of the national dialogue on this topic that had been taking place for decades, and certainly intensively for the last couple of years, all in one place, October 20th regulation. And, of course, then there was a final rule. And these questions, in my mind, frame the issues that the final rule addressed. And I want to keep moving to stay up with my time and to give you all a chance to ask questions. So, again, I won't go through all of the detail. But CMS was faced with articulating the structure and governance, what they expected accountable care organizations to have as their core resource base, including financial resources. Secondly, they had to think about the payment methodology and where along that vertical axis of payment and risk that the ACO provider organization would take, meaning bundled fees, capitation, or pure shared savings. Is everybody kind of clear on that distinction? I mean, pure shared savings is you measure to make sure the quality measures are hit, and then you take a population and you see whether the cost this year was more than last year. Now, that's not exactly the way they do it, but that's the concept. And if the cost for that population was less in this year or the current measurement period, there is a savings. And Medicare is prepared to split that with the ACO and then allow the ACO to allocate it among their participating providers. But if you move to something in which it's prepaid, a capitation or a global fee, you get this amount of money to provide the care, and that could be renegotiated. And then what if all of the care that is asked for by the patients of that ACO is way more than that money that is being paid for? Where does the provider organization have the resources to cover that gap? That's the whole issue we had once upon a time with early HMOs and various kinds of risk-taking provider organizations, some of which went bankrupt. So how they balance that risk issue, how much and how quickly you let ACOs take risk was a key question. What about the managed care backlash issue, the engagement of patients? How do we give patients freedom of choice to go whoever they want and still have them be willing to work with the ACO to get the best care, the right care, at the right time every time, which has been proven to be more cost efficient if you do it that way, not more costly. But would this dynamic, this calculus, make patients and their physicians as unhappy as the push toward managed care in the late 90s did? Remember Harry and Louise? What about actually this process of measuring? Some very sophisticated organizations measure themselves, and what do we mean measurement? Well, what care was delivered in this kind of situation, this episode, and how did the patient do? Did you do the aspirin in the emergency room or the beta blockers with the myocardial infarction at the exact right time every time? Which, in fact, around the country, as far as I know, the statistic on that is about 50% of the time. I mean, there's the exact thing you should do when somebody presents with a heart attack, and it doesn't happen half the time in our healthcare system. And that kind of simple thing. But how many measures, and how well will these ACOs be able to handle measuring and reporting? And then finally, which others this morning will talk about, how well did CMS balance the overlay of regulations, fraud and abuse, antitrust, exempt tax, and others that affect providers, those very same providers that are supposed to come together to be accountable care organizations? Historical enforcement in these areas tended to view collaboration as suspect, right? It's a lot of individual providers getting individual payments. When they share incentives, those could be kickbacks. When they work together and they're competitors, that could be a restraint of trade. So how well did they balance it? Let me say a few things. On structure and governance, the final rule was more flexible. If you form an ACO, you do need to create a new entity, but it's one in which the requirements around its board and some of the other obligations it is required from a formation standpoint are more flexible, and the market reacted very positively to that. But the board remains predominantly and must be the providers who are part of the ACO. Under financial risk, the original rule had a couple of different tracks, one of which moved to shared risk, away from pure shared savings. The market reacted pretty negatively to that, so in the final rule, CMS allowed parties to stay shared savings only during the first 3 years or the first contract period under the Medicare ACO program. There still is track 2, but it's not mandatory. And in a sense, a lot of the experts argue, as we roll these kind of things out and experiment, there ought to be a shared savings, there ought to be a limited option, this is that vertical axis, there ought to be a limited risk corridor option, and there ought to be a more aggressive partial or full capitation option. Well, in a way, with the 2 tracks in the final rule and the Pioneer ACO, you sort of get that. Shared savings is track 1, limited risk is track 2, and more advanced risk is Pioneer. As to the beneficiary relationship, this will still be interesting to test, but there's a lot in there that tries to reconcile the desire of the ACO to be in a dialogue with the patients so they know who their patients are, which in the original rule wasn't, it was going to be a retrospective assignment of patients to the ACO, but to not allow the ACO to dictate too much around the patient's choice of providers. And so that's an interesting part of this experiment. Managed care light, some people call it, but there's a lot built in to allow for a dialogue so that patients would ultimately be educated enough to choose the kind of provider to go to, often soon enough, not wait too long, and so forth. So the final rule addressed that. And, you know, as I say here, the jury is out ultimately on how well that will work. The final rule reduced the total number of measures. The marketplace felt that the total number of measures, because you have to have an electronic health record and a lot of other things that take a lot of investment to measure, that the original rule was too far up that diagonal line on measures, and they dialed it back and went from 65 to 33. And in many ways, that now represents a lot of years of thinking of a lot of organizations like the National Quality Forum of what should be a core measure set for an organization like an ACO, even in the commercial market, and you see the insurance companies adopting it. And then that fifth question was the regulatory balance, and I won't comment much. That's what many of the other speakers today are doing. But that coordinated effort by those agencies I mentioned did end up addressing in corollary guidance the place of ACOs from an antitrust perspective, how the antitrust agencies will view the coming together of diverse providers in an ACO to collaborate, where it's problematic, where it's not. They address fraud and abuse, as you'll hear, and they address the implication for exempt organizations. And my view is that overall, it shows not only that intergovernmental agency cooperation I mentioned, but it shows that the agencies believe that the fundamental act of providers in an accountable care organization, improving outcomes, improving cost efficiency, is a good thing, and that where there are teeth in the organization, meaning it is really changing and enforcing clinical protocols that will drive higher quality and higher cost efficiency, and measuring it and reporting it when there's reality to it. Again, reasonably, maybe even halfway up that diagonal line, then the agencies will generally take a view that it's legal. I'm greatly oversimplifying. The other speakers will get into it, which I think is good, and it promotes coordinated care. But they're also very clear that that's not what's going on, and it's just more form than substance. That doesn't necessarily address these legal barriers. So we will see. Another thing that the final rule did was move back the timetable a bit. Originally, it was thought that ACOs needed to be operational at the beginning of this past January. It pushed back the start date for those participating. Pioneer started January 1, but the Medicare Shared Savings Program is starting either April 1 or July 1 of this year. And for the April 1, they would already have had to put in a letter of intent. The due date for the letter of intent for the July start date is, I think, next week. And then it'll keep going. It's expected to have another round starting the 1st of 2013, and we'll see. CMS estimated, they have 32 in Pioneer, 50 to 270 participating in the shared savings program, probably in the first year. These will be they have 3-year contracts, but new entrants can start at the beginning of every year once we get into 2013. So it remains to be seen what the uptake is and to what degree the commercial market ACOs look a lot like Medicare and how they evolve over the next few years, really whether it's taken to scale and so forth. But certainly the final rule caused an awful lot of organizations to take a second look after that negative initial reaction. And I expect that the numbers of participants probably will be in the range of what CMS estimated. And certainly the shared savings program then, given that history, that statutory base and this complex regulation, I think has a legitimate place. It isn't likely to be deemed, a failure from the start. Again, we'll see what the uptake is, but it has a legitimate place in a sense, the constellation of programs to move accountable care forward. how am I doing on time? I know that 5 minutes to get to questions? Okay. So I have a third section because I wanted to give the general background on accountable care, and I then wanted to talk and was asked to talk about the final rule, but in the context of what they were trying to address. And, as I said, you should read the preamble as well as the rule itself. But clearly it, in a sense, responded to some of the major concerns that organizations were expressing. And so now we have, I believe, as I said, a credible program. Now what? Well, I think, as I said at the start of this, and I find myself, the things I'm being asked to do, we're really moving into implementation, which is very exciting. It's beyond talking about it and saying, should we do this? Most major provider organizations and a whole lot of smaller size provider organizations are in some way, shape, or form moving into a contract or an arrangement with a commercial payer or potentially a government payer that has something to do with changed payment toward value-based payment and or a bundled arrangement, or they're forming an ACO. I mean, it is broadly going on. I certainly see that from a day-to-day basis. But it's moving to a different stage. It's less talk, more action. I think that's right. So who should consider entering this shared savings program? Well, I think everybody should consider. Would be my own view. That's what I tell clients. Doesn't mean they get in that program. There are some folks that are in so many discussions or actually implementing arrangements with commercial payers. They're just saying, I don't have time to do the shared savings program right now. I'll think about it for 13, and that's okay. But they ought to be thinking about it. I think maybe it's on this slide, but I'll go back and forth. They ought to believe in the spirit of it, and it ought not to just be another reimbursement game. I mean, that's a mission point, but it's also the point that fundamentally, unless the ACO is really engaging these efforts and the thing has some teeth, it isn't going to get the regulatory benefits I talked about, and I would argue it's not going to be successful. Oops. So I'm not going to go through all these, but obviously once providers start considering it, they've got to be in a position to have the basic infrastructure to be an ACO. Now, CMS says here's what you need, but interestingly, unlike the application process for Pioneer and some other things where the providers had to provide an awful lot of detail, in many ways the application for the shared savings program just is a certification. I'm oversimplifying some, but basically ACOs have to assert they're able to do all these things. But darn it, if they're not able to, it's going to be a failure. And what are these things? Well, again, it's that question, how far up that diagonal line? Startup ACOs don't have to be able to do what, again, a Geisinger or a Mayo or Cleveland Clinic can do, but they have to do some basic things. An electronic health record is pretty much assumed to be fundamental. A real system to coordinate care. Rules that providers follow that are studied and then can be reported on, measured and reported on, and a financial plan to succeed, even if there's some uncertainty to it, to succeed in this environment, and again, depending on what form of payment is taken on. What makes for winners and losers? Well, sort of the same thing. Enough leadership, a board, a senior management team that gets this and is driving the organization there, that understands that we may be riding, like the trick rider riding two horses at the same time. You're still doing fee-for-service, and you have to survive, make money at that, but you got to switch over to this other, and they're different, and they have often opposing incentives. But you have to do it at the same time, and it takes some financial sophistication and capability, but also a risk, to some degree, a risk. I don't mean that in terms of formal financial risk, a risk-taking spirit because the mission is there. A provider network who has or is willing to continue to develop aligned incentives, as I said, strong governance, and so forth. It's a fascinating process to watch providers address this. Some have been at this for a good long time, and then the question is exactly what's the nature of the network and what risk model should we take on. But there's a lot of others less integrated along that horizontal axis that are saying, we believe in this, but we don't work like that at all. Do we have to get acquired by somebody big? Can we form something? There are some provisions I wasn't able to go into in detail. There's a program in which certain startup ACOs potentially could borrow against their later shared savings to get some of that startup money, but it's there's a national process going on of providers evaluating, again, whether or not they're ready to jump into this program in 2012, where they want to position themselves. Okay, thanks. There's 2 or 3 slides, if you want to look at them, on the importance of boards providing leadership in this arena. There is a challenge to directors of healthcare organizations to say, okay, Medicare reimbursement is going to go down on a fee-for-service basis. The world is changing. Our health plans want to move in this direction. We need to understand it. We need to understand about measuring quality and reporting on quality and doing that accurately and legally, because it can trigger fraud and abuse issues if you report incorrectly. And so just to make the point about governance being an important part of this, and there are a set of questions in here, again, if you'd like these PowerPoints, that I put together that boards should ask themselves, and there should be a robust dialogue within organizations, whether it's the ACO itself or a provider organization that might participate in one, regarding leadership and direction of the organization. And my concluding slide is just that you can talk about ACOs all you want, and that's the current vocabulary, but there's this underlying concept which has legal significance and clinical and financial significance about clinical integration, and that has been at the center of this dialogue, and it speaks to that point of how providers relate to each other in a more coordinated fashion. And sometimes you hear this as the leading edge. What providers are doing is they're getting clinically integrated. That puts them in a position to do a bundle or to be an ACO, but the key is actually getting clinically integrated, and they ask us often, well, are we clinically integrated enough to withstand antitrust scrutiny or to be successful in this program? And that leads to a dialogue about how you really move from fragmented fee-for-service to overall more coordinated care. Thank you. I always enjoy talking about this. There's so much and so many levels of detail we could go into, but I hope that was a useful overview, and it is time. There's an opportunity for a few questions. Okay. Come on, somebody always has to start, or should I, do I call on somebody? Hey, Troy, how you doing? Hey, Tom. Yeah. Would I? Or did I? No. Well, I mean, at one level, you've got a lot of providers that are nonprofit organizations that are investing their own funds. Some people view this as a negative, that for example, large nonprofit health systems are driving a lot of the development. It's not quite a direct answer, and I'll circle back around. I mean, much of the view of where the savings would come from, as well as the improved care, is reduced hospitalizations and certainly reduced readmissions. And so a lot of the large hospital systems are saying, our business model has to change. We have to get into the physician business. They've been doing that for a long time. It's expanding. We have to be a diversified provider. So in a sense, they are investing. But the question goes to whether Wall Street would invest, private equity would invest. How do they do that? We had the episode in the 90s of investors trying to move physician organizations more to scale and aggregate physicians and so forth. I mean, right now, it's pretty clear you don't get into this. I mean, Tom, I'd say this. If your view is, right now during this experimental phase, we would want to form an ACO or be involved in a bunch of them in and of itself to get a return on that investment, that's very speculative. I mean, basically, we're talking about less overall payment and taking a share of it. But whether it's part of a longer-term investment in a proprietary healthcare provider enterprise that is looking at the way payment is going to change, and they're trying to figure out how to work with this emphasis toward primary care and home care and team care and coordinated care, and let's say an organization that understands a lot about managed care that might work with an ACO to help them get the infrastructure to do this and do that as a proprietary contract matter, and you would invest in that company. I mean, I think like anything else, when there's change, it opens up ideas for creativity and innovation for parties that are innovative and creative. And so, yeah, I mean, I think my answer would be, where I look at this purely as where might one invest in this environment, there would be a lot of places to invest. That wouldn't necessarily mean in hospital XY or medical group Z's ACO. For one thing, these rules say that the board has to be overwhelmingly the participating providers, and that's arguably perhaps a disincentive for private investors in the, at least Medicare ACO itself. Yeah, yes, and then. And well, that's an interesting perspective. I mean, the answer is yes. Not only is it a two-step process, it should be. If you're not effectively clinically integrated, you're not going to be successful. I think those folks all, in the run-up to the Affordable Care Act and the regulation, argued that they already were an accountable care organization, right, and that they could do these things, and they would argue they're functioning like that in the commercial market. They basically publicly said, in the end, they didn't feel like the financial model and the particulars of the Medicare ACO program was something that they, at this time, wanted to engage in. Some were a bit critical of it. Others were more like, we're doing a lot of other stuff like this, and so we're going to keep doing that. But I think that is why they didn't, and that got some press. But at the same time, when you ultimately saw the numbers that came into Pioneer, and again, we'll see what happens with this program, it may make the fact that they're not in it kind of a less publicly discussed factor. But your first point is right. I mean, that's sort of that issue with all the folks that somehow in that run-up to the regs thought an ACO would be an easy thing to do. You could just form something without the clinical integration, which is really hard. And the folks that are most clinically integrated, I mean, you know, I'm not trying to say, but an Intermountain, you talk to their medical director who's a clinical informaticist. You know, he'll say, we're only just scratching the surface, even though they've been hard at this for, 20 years. It's a long, complex process, but the hope is we've gotten it started on a broader scale, and that best practices will then be able to be shared more quickly. Yes, sir.
Follow up on the business development question. What about the other end of the spectrum that you talked about earlier? The smaller single practice physicians looking to organize themselves and build up into a group. What are your thoughts about the financial viability of those?
Well, it's tough. And that was recognized, and that sort of was part of the debate about how much infrastructure would be required. And again, there are many, most of the major health plans have various kinds of shared savings, pay for performance programs in various forms for individual physicians. And they tend to be focusing more on that side of the market in many ways, although there are some plans that you probably read have acquired large medical groups or they're acquiring hospitals. But most of the insurance programs are somewhat more startup. They're with physicians, and they're seeking to change payment they would argue in the best interests of patients and the ultimate reimbursement of those physicians and the health plan. So that's an easier way to get in. It isn't easy for a whole group of disconnected physicians to all of a sudden form an ACO. But what you do see happening is more established medical groups, including some primary care groups, that have infrastructure, and they are on an electronic health record, wrapping around some independent contractor physicians and trying to function, whether it's private or potentially, I mean, we don't know who ultimately is going to apply yet to this, as an ACO, under probably shared savings. I mean, on the other hand, there are some very sophisticated physician group-based California, some in Massachusetts, Minnesota, and other places where they've been doing capitation for a while, and they're pretty sophisticated. But again, to the question, it takes a lot of investment and a lot of investment of people time and building the culture of collaboration that success in this requires, that makes it hard to pull together solo physicians or small practice physicians. But there's no question that this is an effort to cause that to happen, and that goes back to, well, is there some capital out there that could be invested to help promote that? And in my view is it's uncertain exactly to what degree that'll happen. Yeah. Last one? Okay. Sorry, I'm running out of time apparently. Yeah.
How's the commercial insurance industry reacting? Are they supportive, or do they view this as like a threat to increase market concentration?
I think you could ask a question about the whole Affordable Care Act. I think they have concerns. I mean, one concern is, basically, do we just get cut out of the equation? Large employers and others can go to ACOs and do this, and what are we doing? On the other hand, the health plan community has jumped into this pretty aggressively in various ways. To some degree, it's still somewhat aspirational. Some people would argue more talk than action, but they're looking to maintain a role. I mean, they're the folks that historically have been able to, who have had the responsibility of care coordination, in a sense, managed care. And so the health plans are rolling out their own payment programs to work with providers in value-based ways and to do ACOs. But I think they remain concerned about making sure that they're actually able to remain a critical part of the process. And, to some degree, time will tell on that. A lot of large providers see it as an opportunity in some respects to bypass the health plans. And, we'll see. Thanks, Evan.
Thanks very much again to Mr. Hastings. That was great. Next, we bring yet another incredibly valuable resource who's been pivotal in the healthcare policy scene over the last decade, Mr. Thomas Scully. Mr. Scully is senior counsel at Alston Bird here in D.C. And also splits time in their New York offices. Mr. Scully was administrator of the Center for Medicare and Medicaid Services from 2001 to 2004. Before that, he was president and CEO of the Federation of American Hospitals. He has also served as deputy assistant to the president, counselor to the director of the Office of Management and Budget, and also associate director of the OMB. We are proud to say that Mr. Scully is a graduate from right here at Catholic University of America, Columbus School of Law, and received his undergraduate degree from the University of Virginia. Mr. Scully will give us another perspective on the progress towards accountable care and focus on the Center for Medicare and Medicaid Innovation's pilot ACO model, another pivotal program in attempts to move towards accountable care. Mr. Scully.
Actually I won't, because I was listening to Doug, and he already did about half what I was going to say. So the good news for you is I didn't bring slides, and I think, just looking at the audience, some of you guys are lawyers. I'm kind of a lawyer, a fake lawyer. In fact, last time I think it was in one of these settings, I was in high school saying I didn't really mean it. Just kidding. So I don't really go to courtrooms much. But anyway, I'm going to talk more about the policy issues, I think, because Doug covered a lot of the details, and we can get it if you want to get into the details of Pioneer ACOs. I do practice law occasionally, like one day a week. Peter Feiss over here kind of works with me at Alston and Bird. I spend most of my time in New York with Welsh Carson, which is the biggest private equity investor in healthcare. So we own a lot of it. We've gone through a lot of these debates, and I think maybe I'm wrong, but it'd be a little more interesting to get into this from the investor side. We have been the biggest investor in the private equity side of healthcare probably for 35 years. We own 16 healthcare companies, 2 hospital chains, an HMO. So I can get into if you'd like to get into our insurance. We had a board meeting about this all day yesterday, about a $4 billion HMO. We just sold the second biggest Part D plan. And we own the biggest chain of ambulatory surgery centers, half the hospitals in Albuquerque, half the hospitals in Tulsa. So we've gotten this from lots and lots of different sides. So I look at it more from the investor side, and I think it's a little more interesting from that. So I'd like to step back, talk a little bit about the big picture policy. What is there about an ACO? Some of you probably didn't see it, but I had a little debate with Don Berwick, the most recent CMS administrator, in the Wall Street Journal a couple weeks ago about this. And I love Don, and I think what they're trying to do is great. But the fundamental issue is a debate between fee-for-service and capitation. And when you really step back, what are you looking at? My frustration with the ACO debate is I think it's a move in the right direction, and it's great, but the fundamental problem with the healthcare system and the fundamental problem with Medicare is the government fixes prices. And I think people ought to think about that. When you step back and look at it and say, what's the most screwed up part of our economy? As much as I love hospitals, and I love docs, and I think the most honorable people in our society are in healthcare, since World War II, as an accident of history, when we developed Medicare and Medicaid, if you're in a hospital, are driving 55, 60% of your revenues. And what drives that? Medicaid in almost every state fixes prices, and Medicare, for 75% of the population, fixes prices. Every doctor, every hospital, every rehab clinician, everybody that's getting paid by Medicare gets paid on a fee-for-service price-fixed basis. That didn't happen with auto mechanics, doesn't happen with lawyers, doesn't anybody else. What would happen in any society, any place, where you pay everybody the same amount? You get volume explosions. It's basic economics. And that's the problem with the healthcare system. I love the Medicare program. I'm very proud that I ran it. But the fundamental debate in ACOs gets back to, what do you really think you ought to be doing? And what's the thing that drives all of our problems in healthcare? What drives all our problems in healthcare is that the federal government, through Medicare in particular, drives everything else. So my first job in Bush 1, anybody around 1989, was passing RBRBS, which is now referred to as the SGR. How many people know what RBRBS is? Anybody? It was the physician payment schedule. At the time, we had huge problems with docs. We were paying them too much money, and we decided, this is the first Bush administration, that we had to go back and put in price targets. And, they kind of worked to save money, but the problem was volume. It's always been volume. If you go out and pay a doc, and I have 7 in my family, $32 for an office visit, which is what we paid them in 1989, guess what we're paying them today? $34 an office visit. What are they going to do? They're going to buy an MRI clinic. They're going to find something else to invest in. They're going to find more services. They're going to see more patients, and you're going to have a volume explosion, and you're going to have a volume explosion of all the ancillaries. So the real fundamental policy issue which ACOs is getting to, and I will get back to ACOs, is how do you structure the healthcare system to work? And I respect what Don did in ACOs, and I think it's a tiptoeing in the right direction, but the fundamental debate is all about the incentives in the healthcare system. And when you're paying everybody the same amount on a fee-for-service basis, you're going to get volume explosions. And when you get into bundling, which is, I'm a big fan of bundling, but bundling is just pushing air around the balloon. So we took DRGs in hospitals, we put them in a bundle. What happens? All the other stuff seeps out of the bundle and goes someplace else like air in the balloon. What happens when we start capitating in ACOs? Guess what? People are going to find other bundles. So the ultimate bundle, which I used to say, and the ultimate answer to this is, and this is the fundamental philosophical issue, we had to do pre-acute bundling, and we had to do post-acute bundling, and then we had to do acute bundling, and we had to bundle the 3 together, call it Medicare Advantage, and get the hell out of the way, which is the fundamental issue about premium support. So my point in getting this is all these debates all come together, and the fundamental issue is, what do you think drives the healthcare system? And as much as I love our healthcare system, I've been on the board of lots of hospitals. I ran the For-Profit Hospital Association for 6 years. I've been a bureaucrat for many, many different places. The fundamental underlying issue in the healthcare system, which Don Berwick and CMS is trying to get to with ACOs, is what's the right set of incentives to make people perform the way you want. And unfortunately, we don't always trust insurance companies. So giving an insurance company in Medicare Advantage, for example, $12,000 and saying, call us next year, only works if you're going to regulate them right. And for those of you, hopefully there's anybody here from the managed care plans, when I was the primary crafter of Medicare Advantage, at least in the last administration, and, we made a fundamental drafting error. We overpaid them. So Democrats are right. Medicare Advantage plans are overpaid, and it was an accident. And anybody that doesn't believe that wasn't sitting there, and we did it. It was not intentional. We did not intend to pay them 115% of fee-for-service. It was a mistake. So we intend to pay a little more, but not a lot more. But if you fundamentally believe the right set of incentives is to give a private health plan, which we do in the Federal Employee Health Benefits System. Anybody here been a federal employee? I was for 16 years. You know what? Federal employees buy private health insurance, tightly regulated with low margins. Federal Employee Health Benefits Plan. There's no government price fix program. You buy a Blue Cross plan, you buy a local union plan, you buy whatever. It's a model the Democrats and Republicans both say, hey, this works, great. It's private health insurance, tightly regulated with low margins, and we didn't overpay them. How does TRICARE work? If you're anybody here in the Defense Department or as a family Defense Department, if you're in the Defense Department, TRICARE is the Defense Department's support program if you're not getting stuff from a defense installation. Guess what they buy? Private, tightly regulated, private health insurance with relatively low cost and overhead. And it works. So the real issue is, do you believe in total capitation, which is ACOs are moving towards? And to do that, you got to be tough, and you got to be a regulator, and you got to beat up the insurance companies and convince them, like we did in Part D. I also, not to be, but I was, I think, the primary cook behind Part D. We had the benefit in Part D of starting with a clean sheet of paper. Part D is a very high volume, very low margin, very tightly regulated, very competitive, private insurance system. And it works a lot more like FEHPP. If you're tough enough to do that, that's probably the right way to go. Now, if you're convinced that, and it's a fact of life in my lifetime, that you got 75% of the population still going to be a Medicare fee-for-service, and you got to deal with them, you got to inch in that direction. So just, again, to step back, when I took over CMS in 2001, the Medicare HMO plan was called Medicare Plus Choice. We had 4% of people in it, and it was fundamentally broken. It was a mess. We very intentionally tried to, we accidentally overpaid it, but we went in and redesigned it, changed the name to Medicare Advantage, and now you have 25% of people in Medicare Advantage. That was extremely intentional because we fundamentally believed that the right way to drive the right incentives in the health system is to take all these bundles, put them in a package, and as much as you may not like Aetna, or you don't like Coventry or Blue Cross, you're much better off having their private capital at risk, and they'll make the right decisions and figure out how to make sure people don't get 6 MRIs in a week because it's their cash. And as long as you have taxpayer cash on the line, you're going to get volume explosions. So I'm saying this all because I think the ACO debate is interesting, but it's a small little sliver on the road of hopefully reforming healthcare. For those of you who are still law students and are still on the policy side of this, the policy issues in the long run, the law issues, Doug's forgot more about the law issues than I'll ever know. I can go through all the pioneer ACO issues, but the real issue is to look at the bigger overall healthcare policy goals, say, where do you want to be? And I'm not trying to be political with Democrats or Republicans, because half the time, if you look at the best healthcare plan out there, as far as the best healthcare reform plan that's the most capitalist, that would work, that would actually change the system, it's by getting Ron Wyden, who's one of the most liberal Democrats in the Senate. But the politics get so carried away, Republicans look at it and say, oh my God, we can't do that. Ron Wyden's for it, so it's got to be bad. It's actually the sanest, most rational plan out there. Democrats say, oh my God, we can't do this because some Republicans said it. So the politics is so nasty in healthcare that the policy gets lost. But the policy goal is to try to run an efficient health system where doctors have the right incentive to provide care to patients and hospitals have the right care to provide incentives to provide care to patients. And unfortunately, this has gotten totally lost in the mix of this. So your next panel is about antitrust. I'm going to try to weave back in the business side and the antitrust side in here. But ACOs are fundamentally a good concept. But what are you really doing with ACOs? It's a tiny, tiny incremental step in the right direction. How can you be against measuring what doctors are doing and paying them incrementally for better results? There's nothing wrong with that. It's a great idea. But if I went out to you and said, you know what, the federal government's going to buy automobiles for everybody. And you know what, we're going to measure the relative level of difference between Ladas and Yugos. Anybody remember Yugos? And we're going to pay everybody the same. We're going to buy cars, we're going to pay them all the same. But we're going to measure it incrementally. We're going to pay plus or minus 1 or 2 or 3%. And we're going to measure these Yugos versus the Mercedes and figure which one works better. That's fundamentally what we're doing in healthcare. We're measuring, we're paying everybody, regardless of what you're doing, the same amount, saying we're going to measure you over the years, and if you happen to be a slightly better producer, we're going to pay a plus or minus 2%. The concept of that in a capitalist society, that everybody's still going to be paid the same thing, and 4 or 5 years down the road, we might pay you plus or minus 2%, is fundamentally nuts, in my opinion. So is it the right way to go? It's better than doing nothing. But when you really look at when you're trying to change behavior, we're in a price-fixed world where we're going to say, we're going to give you a population of people in ACOs. We're going to measure it. And by the way, I spent all day yesterday looking at ACO applications. We're trying to create, so I asked an ACO company through our insurance company that we own, that I'm on the board of. And it's probably a good thing, but we're more for you're exactly right, the future business interests of us developing relationships with docs. And I'm going to get back into that. It's not really a viable business. If you want to get into the world of having the interaction financially with docs, what you're really trying to do with ACOs, which is exactly what HMOs try to do, is try to get to the docs who fundamentally don't understand, sadly, economics, and they need to. Docs control patients. Hospitals are high-tech buildings, office buildings, that house docs. The docs make the decision about where the patients go, and the docs don't have the right incentives. The goal of every managed care plan and the goal of any ACO is to talk to the docs and say, how do we get you to make sure that that patient takes Lipitor, Mevacor, or generic instead of Lipitor? How do we get you to make sure that you see them more often and keep them out of a hospital? How do we reduce their hospital days? How do we pay you to create the incentive to make sure that if they go into a nursing home, they have to get out of the hospital, that they're there for 14 days instead of 30? You need to create the incentive for the people to control the switch about where the care is given. That's what ACOs are all about, and they're very, very small little incentives. A really good HMO, if you go to a good HMO, I would say Humana in Tampa, which has a very doc-driven system. We have one in Houston. We have the biggest Medicare HMO in Houston. The key to success, whether you want to call it an ACO or an HMO, or whatever you want to call it, is to talk to the docs, give them information, and say, you know what, if you do a better job of keeping these people healthy and you lower their trend rate and you make sure that they're happy, we're going to pay you for it. It's not that complicated, and that's what it's all about. And so the concept of ACOs is good, but it's a very, very small movement in that direction. So what are ACOs going to do on the big ACOs? There are 32 of them that came out in December. The good news about it is there are 32 in their big systems. Fairview, hopefully nobody's Fairview's watching this. God bless them, they got one in Minnesota. But who really did it? The biggest problem with this, they were large hospital systems. And what does the world not need if you want to improve health care? Consolidation around large hospital systems. And I hope your antitrust guys are getting into that. The fact that I think it's a joke that they mention healthcare and antitrust in the same sentence. There's been so little healthcare antitrust enforcement in the last 30 years. It's one of the fundamental problems in the system. You want to look at what the biggest example of that? Somebody's probably heard from it. I happen to live in Northern Virginia. What's been allowed to happen with Inova in Northern Virginia is outrageous. Within 50 miles of Alexandria, Virginia, they own everything. Talk about a fundamental antitrust problem. How can you possibly have a competitive health system when one system, they may be the greatest guys in the world, own everything? And as you look what's happened with ACOs, The concept of ACOs was supposed to be, let's empower physicians. Don Burr worked as a doc, and he would tell you this. The concept was, how do we get physicians involved and give them the incentive to say, let's measure your outcomes, measure your quality, keeping people on the right drugs, making sure they're taking 6 drugs instead of 15, making sure they're taking generics instead of name brands, keep them out of the hospital, getting better quality. So let's get docs organized. Well, the problem with the ACO system is if you're really in a decent market and you want to get organized, the IT infrastructure and the design infrastructure is probably $15 million, maybe as high as 30, depending on the market you're in. The docs don't have that kind of capital, and they don't know where to find it. One of the businesses we're doing is trying to help those guys out. So what's happened? Every one of these big pioneer ACOs is a big hospital system. You can call Geisinger maybe not a big hospital system, but it's a big hospital system. They're all pioneer ACOs. The money's coming from the hospitals. What does that mean? More consolidation, more oligopolies, more big power in every market in the country, and that is not good for the health system. That ain't going to drive down costs. It's not going to keep people out of hospitals. I can give you lots of examples. We own the Lovell system in Albuquerque, which is about 40% of the Albuquerque market. We own the HMO, we own the docs, we own the hospitals. Guess what? If you're a hospital administrator, you're not out there telling the docs, please find a way to empty out those beds for me. Anybody know a hospital administrator that wants to empty beds in the hospital they just built? No, they're down at the construction site building the 2 new wings that they just financed with bond money or whatever, right? So, I mean, the incentives are not there for hospital-based systems to drive people out of the hospital, take care of them in the physician's office, lower their volume, make sure that they do less MRIs, even though we just opened a new MRI clinic. I mean, it's just not the way it works. So all the incentives are wrong. I haven't seen one pioneer ACO that was doc-driven. And to be honest with you, I've seen very few ACO applicants because the docs don't have the financing to do this. People are out there trying to put these businesses together. But the concept of an ACO, for those of you alluded to it earlier, was Med Partners in FICOR. We went through this in the 90s. For those of you, a few people old enough to remember this, in the early 90s we had Med Partners in FICOR. And to give you a history lesson for the students in the room here, in the early 90s, Med Partners in FICOR were 2 Wall Street-driven privately backed physician roll-ups, because it's the same concept. Docs need to get control. They can drive the hospitals into more efficient, so they can drive the insurance companies into more efficient. Let's go in every market and organize the docs. So what happened? Med Partners, FICOR, and about 20 smaller competitors with Wall Street money went out and started rolling up doc practices all over the country, and they started giving them stock. And the hospitals all panicked, and they said, oh my God, they're going to buy up all the docs, so we better buy them up too. And nonprofit hospitals have massive reserves, to whom, in many cases, they're completely unaccountable to nobody. I'm sure that your clients might too, but it's just a fact. So every hospital in the country had a bidding war with FICOR and Med Partners, and they way overpaid. They were paying docs for $1 million practices, $5 million. What happens if you're a doc and you get paid $5 million for your practice? You play golf 3 days a week, you don't work as hard. What happens to the companies that bought you? They go bankrupt. So what happened is every hospital in the country went out in the early 90s, and we're going to see this history lesson. It's going to repeat itself in the next 5 years. Way overpaid for doc practices. FICOR and Med Partners with way overinflated public money from Wall Street, way overpaid. They had a bidding war. FICOR went up, belly up. Med Partners went belly up. 25 other smaller competitors went belly up. And every hospital in the country was sitting around in the late 90s saying, holy cow, I own all these physician practices. They look remarkably like ACOs. Did they not? That was the concept anyway. And what did they do? They said, we're losing money. We overpaid for them. We're losing money on all these docs. I can tell you in Albuquerque, we're losing $100,000 per doc when we bought that system. $100,000 per doc. And so what did they do? They did what we did. They said, we gave them $35 million and said, see ya. And they went off on their own little venture. And the docs who were not as efficient trickled off and were cut out of the partnership, and the market kind of righted itself. And that happened all over the country. That's my point. We're about to go through this. The good news is the investment of the Wall Street investment is not there, so you don't have the overheated FICORs and Med Partners. But every hospital in the country is running around to buy up doc practices. Docs are not going to be happy. They're not going to like working for hospitals. They're going to go through the same cycle. It's not going to work very well, in my opinion. But it's very dangerous from a healthcare economics point of view to see all these things consolidating around hospitals. So D.C. has a very fragmented market, but look at Northern Virginia. It's all Inova. You go down to southeastern Virginia, it's all Centera. You go to Roanoke, it's all Carillion. You talk about a competitive market that's going to make sure you have appropriate utilization of CTs and MRIs and other high technology to make sure that you keep the hospital bed days down, which is where all the money is, to make sure the drug utilization is right. That's not where the incentives are going once you start buying up these doc practices, and I'm working for hospital-based groups. So from an antitrust point of view, I hope to your FTC folks come in here. I mean, from my point of view, I used to spend a lot of time when I was at CMS with the FTC, who unfortunately had a hard time because of historical track record in this, trying to make sure there wasn't too much hospital consolidation. The most dangerous thing about ACOs, and Don Berg would tell you this, is they were intended to get docs into big groups and have docs have more power. Instead, what it's done is it's poured gasoline on the fire of having hospitals have more power. And that's a very scary thing if you're worried about cost containment and lowering the spend rate and driving that behavior. So I applaud CMS for what they're doing. I think it's the right concept. How can you possibly be against measurement and trying to measure outcomes and pay people the right amount 2 or 3 days down the road to say, if you lower the baseline, the trend rate and the spend, we're going to pay you more as a physician group? Great, that's wonderful. Except the fact is the physicians aren't the ones that are applying for these things, it's the hospitals. And I think it's a very dangerous place to go. So, when you really look at this, in my opinion, the bigger picture politics is, do you really want a policy issue is, we have 75% of people in Medicare fee-for-service. That's a fact of life. No matter what you believe in Medicare Advantage, it's probably going to be 70, 60. During my lifetime, it's probably never getting above 40% of people in Medicare Advantage, no matter what happens. So you have to deal with the fee-for-service population. And in the Medicare fee-for-service population, this is probably the right way to go. Gradually pay differentially, get more into bundles. Post-acute bundling is a big deal. Probably the most screwed up part of Medicare is the post-acute side. CMS ought to push post-acute bundling. So ACOs are a good idea, post-acute bundling is a good idea. But as a business matter, the real issue you're getting into is in every market, and if you go around the country, every market's different. The fundamental issue is you get 3 moving pieces: the insurers, the hospitals, and the docs. And if you have a healthy market, they hate each other, and they all have relative balance. And that's really, in my opinion, what the Justice Department and the FTC should be looking at. The docs, the hospitals, and the insurance companies should have a nice, pleasant hatred where they balance each other off and they create the right kind of competition in the market. Very, very, very few markets in the country have that. You look at Alabama, one insurance company, Blue Cross of Alabama, dominates everything. The hospitals have no power, the docs have no power, no insurance company wants to go in there. Why? Because there's been no antitrust enforcement for years and years and years. D.C. is a fairly splintered market, it's screwed up for other reasons because of the demographics, but it's not that bad. But if you go around the country, in most markets, you have a very powerful insurance company or you have a very powerful set of hospitals that are very consolidated. Almost no place can I look around the country and say, wow, those docs are really powerful. They're incredibly organized. They drive everything. The only place you come close to that is some of the areas where ACOs have actually happened. You want to look for a model of an ACO, look at Healthcare Partners in Los Angeles or Monarch. So what was Monarch? Monarch was a doc practice that had tons of power. The docs were actually very organized. What happened to them? They just got bought by United. So now the insurers have all the power. But there are very few places in the country where the ACO goal has actually worked. Some places around Tampa, there's a couple of them that work pretty well. With the docs have gotten organized, have a lot of leverage. But the goal of ACOs was really to say, how do we get the docs financially incentive where they have the power to lower hospitalization, leverage themselves against the insurance company, and keep more of the money for the docs? Because how many of you are docs? Anybody here a doc? Does anybody know a happy doc? Anybody ever met a happy doc? Happy young doc? Older docs are happy, kind of, although they're grouchy. It's a miserable way to make a living. I'm an old guy now, but when I came out of college, I have 2 of my roommates from UVA are physicians. That was, it was a wonderful thing to do. It was also the way to get rich, for better or worse. It's not anymore. It's a tough, tough way to go. There aren't a whole lot of young kids coming out of med school. Thank God there's still people who want to do it, but, it's not a real lucrative profession anymore. Most of the people in this room are going to make a lot more money than the docs you know. And that's probably a good thing in some ways. There's a balance in it. But docs have been basically, it's not the economics of being a physician, especially a primary care physician, which we're almost worried about, are not too great anymore. And that's kind of a scary thing for the health profession. So in the long run, the goal of ACOs was to get back to the people that actually provide health care, physicians, okay? The people that are running, I love hospitals. We own a bunch of them. Hospital administrators don't provide health care. Physicians provide health care. Guys at United Healthcare and Blue Cross don't provide health care. And the people that should be driving the system, if you really want a more efficient system, that need to be incentivized to do the right thing are docs, and that's what ACOs were all about. And my biggest frustration with both the Pioneer ACO, which is wonderful, or the ACOs going forward, is the incentives to get docs in. The capital needed isn't there. The incentives are amorphous. That's where I asked, if you're looking at it in economics, you say, how do you measure what your ACO, I don't know if you went through this, I saw you went through a little bit. What's the measurement group you have? They go in and say, well, we're going to look back and take a snapshot in Houston. We own the biggest HMO, Medicare HMO in Houston. So you went in and said you want to create an HMO in Houston. We get a snapshot 3 years back of who we thought we might project might be your population. Going forward, we're going to measure and pay you for a whole different group of people that we're not even going to tell you about until after you start this company. I don't know if anybody else here is in the capitalist world like I am, but you tell me you're going to invest in that model? I'm going to give you a snapshot of 3 years ago. And by the way, I'm going to give you a baseline, and we'll measure it. By the way, we're the referee, you have nothing to do with it. And then over the next 3 years, we're going to take a whole different population. We're not going to tell you they are yet. We're going to measure them and let you lower your spending versus that, and maybe we'll give you a bonus down the line. I can say, my God, I can go out and buy a plumbing supply company. Why would I spend my money on that? So the model, the concept is right. The idea is right. What they're trying to do is right, but it's very marginal change. And it's, in my opinion, a much simpler way to change the health system, to do what you're doing in FEHBP, or do what we did in Part D, or do what we tried to do in a very flawed way. And Democrats are correct about that. Medicare Advantage was overpaid, and there were some mistakes made in the way that thing was put together. But to basically say, look, this is all about creating the right incentive. The right incentive is to give people a low margin and create an incentive where some third-party capitalist is taking all the risk. Call me next year. Here's a private insurance plan. We're going to regulate the hell out of you and make sure it works right. And you can get 4% margins and on a high volume, and we'll let you go figure out where this volume is going to go. And you know what? Good docs will get paid more. If you look at good HMOs that are well-run in the right market, they find the better docs. They pay them more. They get better outcomes. They keep people out of the hospital. They have lower volumes of MRIs and CTs. They have lower volumes of high-utilization scans, and they don't see the kind of silliness that goes on. So who looked? Did anybody read the Wall Street Journal yesterday? See that wonderful article about the on the front page about the hip surgeries in California and the workers' comp? I mean, you read that article and you'll see exactly what's wrong with healthcare. And that is the best example I've seen in years of what goes on in healthcare. The workers' comp situation in California pays a fee for service for workman's comp claims. So what happens? There are 4 or 5 hospitals in and around LA, crappy little hospitals that you would never want to be in, that do absolutely nothing but workers' comp hip surgery at $500,000 a pop. And why do they do that? Because the government hung a carrot out there and created that incentive, and people follow it very fast. And the guy that did most of it had come out of prison, and nobody knew it. I don't know if it's worth going back and reading yesterday's front page of the Wall Street Journal. It's one of the wilder healthcare stories you'll ever see. The point is, people, even in healthcare, even though they're wonderful people, they follow financial incentives. And whether it's at ACO or whether it's Medicare Plus Choice or whatever you want to call it, this is all about creating financial incentives for people to follow. And the ACO model is wonderful and great, and I can go through, I'd be happy to go through with you all the incentives for the Pioneer ACOs. The Pioneer ACOs were basically designed for big hospital systems because the way they were set up, you had to take more risk up front. You got a little deal up front, a little more predictability up front, but the only way in the world you could apply for one is if you were a big hospital system, because nobody else had the capability to take risk, nobody else had the capability to model it, nobody had the capability to look at it. That was not what the intent of this thing was, and I've debated with Don Berwick a lot. And I love Don, and he's a saint. He's trying to do the right stuff. But you know what? When you get out in the real world and follow what happens, people follow the money immediately. It doesn't take long. And all the healthcare incentives and all the reasons the problems that the healthcare system is screwed up are directly and completely related to money. There's nothing wrong with that. But if you create an incentive for more volume and you create an incentive to do the wrong thing, people will follow it very, very quickly, whether they're nonprofit or for-profit. And I think that's the biggest problem. So I'm a big fan of ACOs. I think it's going in the right direction. We are going to probably start one, which shows we've actually got we're actually providing the capital. One of our theories is there are a lot of docs out there that don't want to be in hospital-based ACO. They're dying for capital. If you can go out and give them 4 or 5 years of long-term capital of $15, $20 million and give them the IT to set it up, they're starved for the opportunity and they'll do it. And we're going to try to provide the opportunity for them to do that. But docs are not capitalists for the most part. They're not in the habit of doing this, and a lot of them that are older got burned by the FICOR Med Partners model, which I hope they weren't a client of yours, Doug, but I watched it happen 10 years ago, and they're very skeptical. But that really is what you're supposed to be doing to drive the change in behavior, is provide docs with the right incentives. So I didn't cover anything that he asked me to cover. I got my 5-minute notice, but I really think that this is a bigger picture. The ACOs are great, and everything they're doing is right, and I applaud them for it, but the idea that this is going to change the healthcare system, not in my lifetime. It's a small incremental move in the right direction. And the fundamental policy debate is whether the government should be out there fixing prices, and if that's going to work, which it doesn't, or the government should be in the business, like we are with federal employees, of buying tightly regulated, and that's the big key, tightly regulated private insurance and providing people the right incentives. So you want me to answer questions? Or? And I didn't even talk about ACO, so be the last time you'll see me here. Good luck for you. Go ahead, sorry. Yeah. Well, we're a big private equity firm, so we don't, so there may be venture funds out there. I think for you, it's not just, you can be in pockets of groups, but I think you probably have to have, in a decent-sized market, at least 100 primary care docs. and physicians involved in that to make it worthwhile. I mean, you know, a company like ours, we're going to probably go into 30 markets, and if you can get 100 docs in a decent-sized market, you're probably in good shape. You know, the best models, if you look at the ACOs have worked in one place, California. Monarch, which was just bought, Healthcare Partners, and Heritage. And if you look at the balance between the hospitals and the health plans and the docs in California, one of the reasons California has very efficient health care is because the Knox-Keene laws allowed docs to take some risk. And years ago, all the healthcare plans started subcopping out the docs, and the docs back then, for whatever reason, had the capital. And if you look around most of California, there are pretty big, pretty organized doc practices that have a lot of leverage that drive better health care. And those docs know their outcomes, they know what their patients are doing, and they understand for one reason. They get paid to make sure the patient stays healthy. And it's in their incentive, and they get incentive to do the right thing. But if you're a doc, if you're a 58-year-old doc, I'm 54, so one of my best friends is a surgeon for years. He quit half years ago. If you're a surgeon and you're getting paid less, half, is what you work for doing a surgery. When you were a 29-year-old surgeon, what this guy probably wasn't as skilled, and when he quit he was 52, you get paid half as much for the same surgery in Rocky Mount, North Carolina. 25 years later, what are you going to do? You're going to find a way to invest in a surgery center or an MRI clinic or 15 other things to churn volume and put out more stuff. And the government, they think, wow, we just cut surgery fees in half. You didn't cut surgery fees in half because his incentive is to do more. And that's what you're going to get. You're getting more volume. Or if you went out and said, let's find a model to incent you to, you know, make sure that not only do you great hip surgeries, but you get that patient out of a nursing home and into a rehab outpatient clinic and into home health and have the entire, you know, incident of care be 20% less, they would do that because they're the ones that are driving that. But that's not the incentive. The incentive is to check a box and, you know, and churn as much volume as you can. It's just, it's like the sun coming up in the morning. It's not rocket science. Yeah.
From a patient care perspective, I think one of the concerns that I have is if you incentivize physicians too much on increased hospital stay, what they've noticed is places that do that, physicians won't take a medically complex patient, they won't take a high-risk pregnancy, they don't want to look at those patient populations because suddenly their rating goes down. How do you propose a policy which will incentivize physicians not only to do the best they can for the standard patient, but to continue to accept the patients that are going to, by necessity of comorbidities, have longer term stay?
Well, this gets to another complicated question, but I'll torture you with the answer. I was on the board of Oxford. I mean, there are a million ways to answer that question, and you're somewhat right. I mean, there are you're always going to have some hospitals that are going to, you know, the argument is if you're a heart doc, we own a hospital in Albuquerque, and across the street's the Albuquerque Heart Hospital, and the argument is the surgeons take their low-risk, high-margin patients to the heart hospital, and they dump the rest in the public hospital. There are ways to get around that, and that's always going to be some of that. But from the HMO incentive, I was on the board of Oxford Health Plans, which some of you may not remember, was the biggest HMO for years in New York for 8 years in between Bush administrations. And the joke in the 90s was, you know, you put your enrollment office on the 40th floor of a walk-up, right? Because we used to pay all HMOs the same thing. So a 96-year-old cancer patient got paid the same as a little different, but not much, as a 70-year-old marathoner. So you want to find only sick people. And what Medicare CMS did, and I was very involved in developing, was called risk adjustment, where now you get paid, and this has been a huge change in managed care. 10 years ago, every HMO and Medicare wanted to avoid sick people at all costs, avoid sick people. Now it's exactly the opposite. You have SNPs, special needs plans. What happened? CMS started paying people a risk-adjusted payment. So now, if you have a really complex 94-year-old, you might get paid $40,000 a year. Now the insurance companies are falling over themselves to find the sickest, most complex patients because it's not real rocket science. If you have a $40,000 patient, you get a lot more margin by finding a way to treat them for $32,000. And if you get a $10,000 patient and you're killing yourself to try to treat them for $9,000, right? So the entire dynamics of HMOs and Medicare changed with that one change, risk adjustment. And that's basically the issue. And the government has to do that and say, look, we're going to risk adjust your payments, whether it's capitation as you get to broader payments for hospitals. You take more medically complex patients that have more problems, we're going to pay you more. And we're going to create that risk because people follow the incentives. So we completely, in my opinion, I don't know if anybody follows this, but the biggest change in Medicare Advantage, and one of the main reasons it went from 4% of the population to 25%, is that we started telling the HMOs, and there's some gaming going on that too, as Doug knows, you know what, you find a really complex patient, we'll pay you for them. And now they're just falling all over themselves to find complex patients, which is a good thing. And guess what? The most complex patients are now going to Medicare Advantage, and the costs are coming way down. And people complain about Medicare Advantage, but some of you noticed a couple weeks ago, the premiums went down 20% this year in volume, despite all the complaining about cuts. The percentage of people getting the Medicare Advantage is going up, And the premiums are coming down for one very basic reason, especially if you're a low-income person, which it sounds like you're concerned about. The competition between Medicare Advantage and Medicare is not between Medicare Advantage and Medicare. It's between Medicare Advantage and Medicare plus Medigap. And Medigap, for those of you who are still students, is the most garbage piece of insurance ever known. It has nothing to do with Medicare. Almost everybody that buys Medicare that's not poor buys it. It's unregulated, 60% medical loss ratio insurance. That's horrible for consumers and incredibly expensive. So what happens if you're a middle-income senior is you look at it and say, I can join Blue Cross of Highmark Blue Cross in Pittsburgh. Pittsburgh's now about 40% managed care with a good drug benefit and low copayments and deductibles for $100. And you say, oh my God, Congress cut the payments. Now I have to pay $200 a month. That's outrageous. Well, your other choice is to go buy Medigap insurance for $500 a month. And it's horrible, and it provides all the wrong incentives. So increasingly, that's what's happening in the population is people realizing that, especially for lower-income people, Medigap is a really horrible policy. It's not regulated by the government. It's very abusive of seniors, and that's really the choice. But, risk adjustment, I think, is the answer to what your question is. Yeah, because I'm sure that was very confusing there, but you. Yes, ma'am.
You identified government pricing as the major driver of the high cost of the U.S. medical system, but most European countries have government-controlled medical systems where they deliver better outcomes at lower cost. What do you think explains that?
They do, but if you look at Germany or the Netherlands or almost any other, France is different, but France is too much of a mess and too many. If you look at Germany, the Netherlands, most of the other things, but they basically, our system evolved by accident after World War II. Medicare was created in 1965 as a, political compromise, a fee-for-service government insurance company, and we created all these crazy tax incentives that also created the bizarre system we have for the private insurance. What happened in the Netherlands and Germany and most of those countries that work as well is they had basically what you would consider to be, I wouldn't say an ACO model, but a community-based model. They basically have exchanges. And by the way, I don't like everything in the Obama plan, but the concept of exchanges is correct. They're community-based insurance plans with the risk and the community insurance coverage run out of communities. And it's not generally price-fixed fee-for-service. We have one giant national insurance company that fixes prices. In the Netherlands and Germany, which are the most common models people look at, it's a community-based kind of exchange model that's run by kind of a local regional corporations, and it creates totally different financial incentives. And I think it's actually not. It also doesn't perfectly work, but it's a hell of a lot better than our model. And the other problem is we have three different models. If you look at our economic system, if you're running a hospital or a doc practice, you've got, just look at hospitals, because seniors use a lot of health care. If you're a hospital administrator in the average hospital, 40% of your patients come from Medicare, and the government's fixing the prices on that, right? So maybe probably 15% of your patients are Medicaid, and every state's different. There's no one Medicaid program. There's 56 different ones, but generally, the government's fixing prices for that. So there's 55% of your volume, right? Another 10% are uninsured, and the rest are split among 7 or 8 commercial insurance companies that generally piggyback on the Medicare price fixing. So you go to Aetna or United, they're generally paying a percentage of RBRBS to the docs and some percentage of DRG. So even their systems are ratcheted off the Medicare price system. So nobody's leverage outside of Medicare with any hospital is particularly big. And that just happened it's nobody's fault, it just happened over the years. But those are the incentives you're looking at if you're a hospital administrator. And those aren't necessarily healthy incentives to change the behavior of a hospital. You're going to follow the carrots you have out there generally driven by Medicare. So, that's not what happens in the rest of the world. You look at the rest of the world, there are much less hospital-based systems. The infrastructure based on hospitals is much lower. The infrastructure in community care and physicians is much higher. It creates totally different incentives. Yeah.
My question is, and kind of follows up with the woman's question over there about what is going to be the role of the Medicare beneficiary? You identified the power sources in this new equation with ACOs, insurers, and hospitals, and providers. But what is the Medicare beneficiary going to do? What's going to be the impact once this really sets in? And I don't know whether or not this is a question that you have.
I don't think it's going to affect any Medicare beneficiaries, but I hope that the impact on Medicare beneficiaries like me, and I'm 11 years away, is going to have to be much more engaged. Because in my opinion, the two biggest problems with Medicare are price fixing and the fact that nobody knows what they're paying for. So Medicare is fundamentally a $11,000 a year insurance plan on average for every senior, and they're paying $1,100. So what's not to love? So, my problem with Medicare, if you're a poor person, you pay nothing. So the dual eligibles, which is roughly 14 million people, so out of the pick your number, 50 million people on Medicare, 14 million of them are dual eligibles. I mean, they're dual eligible between Medicare and Medicaid. They pay virtually nothing. So poor people are covered and pay nothing. And I'm fine with that. That's probably the way it should be. As you go further up in the income stream, most middle-income people probably should be 90% subsidized. Medicare is a 90% subsidized insurance benefit. So who in this world, in this room, wouldn't love to be having some benefit paid for where you're 90% paid for by somebody else? Well, the reality is you're getting 90% paid for by the guy digging ditches out in front of this building. Okay, that's what finances this, the Medicare HI tax. And seniors are completely disengaged from the cost. Okay, my mom got sick when I was running CMS, got osteomyelitis in the hospital for 5.5 months, ran up an $840,000 bill, and you know what she paid for it? About $1,000. So, and she was totally insensitive to any of the costs. What doctors came to see or anything else, because that's the way the system's set up. That's not healthy. My mom's not rich, but she's not poor. So the complete lack of incentive, especially for wealthier people, if have any concept of what we're paying for and what's going on in the healthcare system, is very dangerous. And for people my age who can afford it, it's got to change. And I know that a lot of people that say, oh, we can't means test the program anymore because it's going to undercut the social fabric of the Medicare program. Social Security is much more means tested than Medicare is. Medicare can't go on the way it is with the vast bulk of the public being oblivious to the fact that they're 90% subsidized. There's just too much money going around. It's a $500 billion a year program right now. And Medicaid is a $450 billion program. Medicaid's a different story. But the number one problem you got in the federal government, by far, is Medicare and Medicaid. My old agency is significantly bigger than the Defense Department, a lot bigger. It's over $1 trillion this year. And you know what? Everybody's just kind of happily cruises along. But the fact is, you know, these things are funded by the HI Trust Fund, which is a payroll tax coming at everybody out front here digging ditches. And, you know, the general revenues funds Part B. So the number one problem I have with it, we're not going to change it, nor should we change it for people that are over 65 and close to it now. But going forward, for everybody in this room who's not over 55, it's nuts, and it can't be maintained. And at some point, you have to go to some kind of a, in my opinion, more efficient private insurance where you're buying well-regulated private insurance and telling people, depending on your income, you're going to pay more. So I've happened to have done reasonably well in my life as a lawyer. I don't think when I hit 65, I should get an $11,000 insurance plan where I pay $1,100. I think it's crazy. I think it's crazy for the guy out here digging dishes and building a new building in front of here to be subsidizing 90% insurance for some guy who's a multi-billionaire paying golf in Naples, Florida. That's the fundamental issue, is a total disconnect. Price controls and the disconnect between who's paying for it. And I think at some point we're going to have to deal with those things. And those are the single biggest two issues in our federal government and balancing the budget. And I'm happy to pay more taxes if I have to, but I tell you what, these entitlement programs are completely out of control. They're wonderful, but they shouldn't be. We shouldn't be collecting taxes from rich people to subsidize rich people, or even higher middle income people to subsidize higher middle income people. And I've dealt with many years of going to ARP rallies, and I love the ARP, and I love all the seniors groups, but this is all economics. You know, unfortunately, in a community of 300 million people, we all lose track. The reality is it's a room this size, and we're all paying for each other. There is no free lunch. Somebody's paying for all the stuff. Yeah, I spent 16 years in the government, 2 administrations, mainly doing poor people's programs, and I did Medicare and Medicaid, but I had food stamps and all the social insurance programs in Bush 1. And look, if you're poor, that's what the government exists to do. I think defend the country and provide basic goods for poor people. So I have no problem with subsidizing poor people, but the vast bulk of people in this country are not poor. There's some incremental amount above that. And if you're, on the healthcare side, not politically popular, if you're obese or you smoke, or whatever your behavior is, you should be somewhat marginally incentivized to change that behavior. And if you don't, then fine, you ought to be paying for it. If you want to ride a motorcycle without a helmet, I think you should pay a hell of a lot more insurance if you're that stupid. So, I mean, it's not that different. We're all in it, but people, because these public insurance companies seem to think that somebody in another country is paying for the stuff. We're all paying for it. So there's nothing magic about it. I mean, I think it's outrageous, both Republicans and Democrats personally, that we have a payroll tax cut holiday. I mean, think about how outrageous that is. We got a $1.4 trillion budget deficit, and we're saying, you look at your paycheck, congratulations, well, you get paid less. I don't need that tax cut. Maybe you guys do. But the fact is, that's the Social Security. The one thing that's supposedly sacrosanct in this country is Social Security. And we're saying for 2 years now, we're taking 2% of the Social Security Trust Fund and not collecting those taxes. And by the way, for the next 10 years, it's going to be everybody that tries to put that back in. That's been there since 1930. It's been changed. But that fundamental tax, paying for the Social Security and the Medicare trust funds out of that tax, has been around for 40 years. It's now a tax increase to put it back in. It's completely outrageous and unbelievably irresponsible. So, I mean, this is all about communal social programs. And if you're not going to be responsible about it, we're going to have a mess on our hands forever. And Medicare is the biggest communal social program now, and Medicaid's so screwed up. I would take another. I wouldn't get into Medicaid. The good news about Medicare is it's only 1/100 as screwed up as Medicaid. Sadly, nobody wants to talk about Medicaid. Good enough. Thank you, guys.
It takes a minute to warm up, and he did talk a little bit about the ACO Pioneer model and sort of the problems with that in aiming it towards major hospital programs. So that was great, and everything else was very enlightening and informative. So thanks very much to Mr. Scully for that. Our final presentation this morning will focus on one of the major regulatory issues that must be taken into account when incentivizing integration and fiscal coordination between different entities' tax issues. Our presenter is Mr. Robert C. Luthien. Mr. Luthien is partner at McDermott, Will & Emery here in D.C. Previously, Mr. Luthien was an attorney in the Exempt Organizations Technical Division of the IRS. He's a graduate of William & Mary Law School, and he got his undergraduate degree from Wake Forest University. Mr. Luthien will tell us about ACOs and their constituent parts operating as nonprofit entities and some of these issues that arise when tax-exempt and non-tax-exempt organizations work within the same pecuniary framework. Here's Mr. Luthien. What you do with this is to go down, use this thing on the right.
Okay. Thanks. I took my time walking up here, so the applause would be a little longer. Thank you. I don't know about you, but I'm depressed. So what we're going to talk about today is how these ACOs work from a tax standpoint. The life of a tax lawyer is an endless series of telephone calls at 11:59 p.m. on a deal that's about to close at midnight, and they ask you, do you see any tax issues in this deal? There often are, and ACOs are no exception. We're going to talk a little bit today about the earlier you start planning ACOs from a tax-exempt perspective, if there are going to be tax-exempt participants in that, the better served you're going to be in the long term. So here are the basic issues that we need to address today. The first issue is just, can a non-provider accountable care organization qualify for an exemption on a standalone basis? And you're going to hear the phrase standalone a lot today. And so when I say that, what I mean is that we're forming a new organization that is going to be an ACO. That's to be distinguished from the second thing I want to focus on today, and that's when you have an existing tax-exempt organization that's going to participate in an ACO. So again, we're going to be looking at ACOs in and of themselves. Can they qualify for exemption? And then secondarily, if we have an ACO out there that may not be tax exempt, for example, can a tax exempt hospital participate in that ACO, and how so? Why is exemption important? One of the things you've heard a couple of times today is that clinical integration is expensive. And as a result, if tax-exempt hospitals or even for-profit hospitals are not involved, the doctors aren't going to have the capital in order to create the clinical infrastructure necessary. So hospitals, both tax-exempt and taxable, are important sources of revenues to help get ACOs going. They're also, if an ACO gets tax exemption, for example, it's not subject to sales and use tax in most jurisdictions. So to the extent computer hardware, software is needed, it can be purchased on a more cost-effective basis. There's also a halo effect that you get when you're tax exempt. And by that I mean tax-exempt organizations are often viewed on a higher plane. And so if you're a patient and you're a little nervous about joining an ACO, whether you know you're joining it or not, you might be more comforted, if you will, by the fact that it's a tax-exempt organization. It's also important to understand how the IRS views issues, and we're going to talk a lot about the IRS. The IRS tends to like to fit things into boxes. So when you are an ACO that's going to apply for exemption, or when you're a hospital that's going to participate in an ACO, a tax-exempt hospital, the IRS is always saying, okay, have we seen this before? What was our analysis? And that's important to the IRS because over the years they want to be consistent in the analysis they provide to similar type organizations. So we're going to talk a little bit today about PHOs as well, physician hospital organizations, which were creatures largely of the 90s. And basically looking at the IRS initial take on ACOs, they see a lot of PHOs in ACOs. Healthcare is wonderful for acronyms, by the way. Well, the IRS ultimately ruled that PHOs, with very limited exceptions, are not entitled to tax-exempt status. And so ACOs already come in with a little bit of a chip on their shoulder. They have to demonstrate to the Internal Revenue Service that they're not PHOs. And I think that's easy to do, but nonetheless, they do have to prove the case. One other concept that I want to talk about, and we're going to start at a very basic level and then slowly get a little more complex as we go on, is that we have to distinguish between nonprofit and tax-exempt. Nonprofit does not mean tax-exempt organization. All nonprofit means is that that particular organization is organized under a state's nonprofit code, and there's certain rules that would apply under the state law. It doesn't really have anything to do with tax exemption. You can be a nonprofit organization that's tax exempt. You can be a nonprofit organization that's taxable. It also doesn't mean you can't have a profit. Instead, nonprofit typically means that under state law, you generally aren't allowed to have shareholders and make distributions to parties in the form of dividends. And that's really about it. And it's important because one of the things we're going to talk about today is nonprofit corporations. And when I say that phrase, realize that I don't mean tax exempt. I'm talking about a type of corporate entity under state law. So what are the basic legal issues for standalone exemption and participating in ACOs by tax-exempt organizations? Well, and again, this is going to be very generalized, but in order to be tax-exempt as a Section 501c3 organization, which is the same section of the code that exempts universities, hospitals, churches, scientific research organizations, a whole host of types of charitable organizations, you really have to show, first off, that you're organized and operated for a charitable purpose. And so in a little while, we're going to talk about ACOs and what possible charitable purposes they serve. You also have to show that no part of your net earnings inures to the benefit of private individuals or shareholders. So basically, this is getting at unreasonable compensation, favorable business deals with insiders, and that doesn't come up too frequently in the ACO context. But the second part does. And that's you have to demonstrate as a tax-exempt charitable organization that your activities don't further what are called private interests more than incidentally. So what does that mean? Every time you all go to a hospital and get treated, you're realizing a private benefit. That's a benefit that's personal to you. However, when you look at that benefit, the IRS has determined that that benefit is both qualitatively and quantitatively incidental to the public purposes served by the organization. So there's a weighing anytime you have a private benefit type issue. With ACOs, the classic private benefit type issue is how much subsidization or capital can a hospital provide to an organization that helps the physicians, but that the organization as a whole still qualifies for exemption and or only furthers incidental private benefit. So that's one of the tensions that ACOs have with the IRS. A couple of examples, PHOs I mentioned a while ago. Again, PHOs were organizations formed in the 1990s mostly. They were basically contracting vehicles. The idea was that hospitals and physicians would come together, seek global capitation arrangements, and they set up separate organizations to do this. The IRS looked at those and said, you know what, contracting with physicians just isn't a charitable enough activity. It furthers the private business interests of the doctors too much, and so we're not going to grant exemption to them. Doesn't mean a tax-exempt hospital can't participate in them, but the PHO itself, with very limited exceptions, couldn't qualify for exemption. RIOs. There are a bunch of acronyms, RIOs, HINs, HEs. All of these refer to organizations that are engaged in electronic health records in some way, shape, or form. A RIO is a Rural Health Information Organization. From about 2005 on, RIOs, health information networks, HINs, were being created around the country to facilitate the adoption of electronic health records. And during this period, it was realized that RIOs, like ACOs, need capital to get up and running, significant capital. And where was that capital going to come from? Well, it was primarily going to come from the hospital community again, because there were no other sources that really had significant revenue. And so we're obviously immediately presented with a problem. Hospitals, as a general rule, cannot provide cash and/or benefits for the benefit of physicians, except with very limited circumstances. The Stark Law, which we're going to talk about a little bit later today, obviously provides significant limitations on the ability of a hospital to provide services or benefits to a physician. Tax-exempt law does as well. And so the government, the federal government, was really behind the formation of these organizations, but they weren't being formed because there wasn't enough capital, and the governmental regulations were a little bit too stringent to really encourage people to do this. So CMS came out with a position early on that allowed hospitals to subsidize part of the cost of forming a rural health information organization or a HIN or any of those. And that helped kind of free up the capital a little bit. And so it showed the government did want these things to happen. It provided a little bit of encouragement. And sure enough, RIOs did start to be formed. The IRS took them a while. CMS came out with their position, and for about 7, 8, 9 months, the IRS hadn't released a position on RIOs. And whether or not that subsidization that's now permitted by CMS is also permissible for a tax-exempt organization to provide, or would it be too much private benefit? Well, about 9 months later, the IRS came out with something that's called EHR Directive, Electronic Health Records Directive, and it said basically as long as you satisfy the CMS safe harbors, then you'll be fine from an IRS standpoint as well. That's going to come back in the ACO context as well, which is why I bring it up. Participation in pass-through entities. So now forget about standalone exemption. You're a tax-exempt hospital, there's an ACO being formed in your area, and you want to participate in that ACO. Can a tax-exempt organization participate in a joint venture that is not a tax-exempt organization? It's a for-profit entity, and the answer is yes. You do have to mind certain safeguards, but yes, as a general rule, you can. Very generally speaking, you have to pass a two-part test. You have to show that your involvement with the organization furthers exempt purposes, and that no impermissible benefits, if you will, go to the other joint venture participant. So, for example, if a hospital puts in 50% of the capital, it should be getting 50% of the profits interest. It should be getting 50% of the control of the organization. Just kind of a general rule of thumb. If it doesn't get that, it at least raises the inference that that may not be permissible to act for that hospital to participate in the joint venture. Control is a very important issue for the IRS. Control of the joint venture by the tax-exempt participant. As a general rule of thumb, the IRS says the more the tax-exempt participant controls the joint venture, the better that's going to be from a tax-exempt standpoint. So it's safer for hospitals to do that type of activity. Now, of course, one of the requirements to be an ACO is that you have, in essence, a broad-based governing body over the ACO, which the hospital won't necessarily control. And so already we have a little bit of a conflict between what CMS wants and what the IRS wants. Doesn't make it impossible to navigate the two, but nonetheless, there's at least a little inherent conflict there between what CMS is asking and what the IRS is asking. Okay. Okay, so let's focus on whether or not a standalone AC entity can actually qualify and what those charitable purposes would be. We're going to talk loosely in terms of Medicare ACOs. Those would be the Medicare Shared Savings Program, MSSP ACOs, the Pioneer ACOs. We're going to talk about Medicaid ACOs, and we're going to talk about commercial ACOs. And by commercial ACOs, I just mean ACOs that include patients that are not part of the Medicare program or Medicaid program. It's private ACOs. So what are the exempt purposes for the different types of ACOs? Well, there are really three possible bases for tax-exempt status for ACOs. The first is promotion of health for the benefit of the community. The second is lessening the burdens of government. We're going to talk about both of those in a second. And the third is relief of the poor. Get over there. While they're putting it up there, we can go ahead and start talking. The promotion of health for the benefit of the community. This evolves from a 1969 IRS position that's still on the books and still is the basis for tax-exempt status for hospital organizations. So despite the fact what a hospital is has changed greatly since 1969, that's still the fundamental basis for tax-exempt status for hospitals and other healthcare type organizations. So it is possible, I think, for an ACO to qualify for exemption under the promotion of health for the benefit of the community analysis. In a nutshell, let me refer to that. In an applicable part, what an ACO would have to show is that its governing body is broad-based. So here's an example where the IRS policy on that may be consistent. The more broad-based the governing body of the ACO, the more likely to satisfy the promotion of health for the benefit of the community rationale for exemption. Secondarily, the ACO will have to show that it promotes health for the benefit of the community as a whole. So what does it do that? Producing better quality outcomes, cost efficiencies, improving access to care. Those are all examples of facts that the IRS has found to promote health for the benefit of the community. Here are three examples that the IRS has already ruled on in the past. And recall that the IRS likes to fit things into boxes that it's seen before. These are all examples of organizations, none of which provided health care as part of their activities, like ACOs, but all of which were found to be exempt by the IRS as charities on the basis they promote health for the benefit of the community. And the Health Planning Agency is particularly of interest. It's somewhat similar to ACOs. Just in case people aren't familiar with the IRS, rev rules, which are what these are all from, revenue rulings. Revenue rulings are binding precedent on the Internal Revenue Service. They're official positions of the IRS that you as taxpayers can rely on. You don't have to fall within the confines of a revenue ruling, but if you do, you can be assured that the IRS would rule on your facts just as they did in the revenue ruling. So these are very helpful. Lessening the burdens of government. Completely separate and distinct bases for tax-exempt status as a charity. And again, you only need one basis for exemption. You don't have to satisfy all of these. Well, lessening the burdens really has two tests as well. First, you have to show that a particular activity of the organization is a burden of government. So you have to show it's a burden of government. And then secondarily, and logically, you have to show that your activities relieve that burden. It takes them over. So not everything that's for the government is going to satisfy this. You know, the contractor who cuts the lawn on the mall is not going to be a charitable organization because they're doing that. That's not the type of burden of government that they're talking about here. But let's go back to RIOs. RIOs, again, Rural Health Information Cooperatives, were hinted at by President Bush, backed by cash by President Obama, and as a result, over time, they were starting to develop enough support for the IRS to get comfortable that these organizations lessen the burdens of government. Then, just before the IRS started to rule on these types of organizations, the American Recovery and Reinvestment Act was enacted. And in the congressional history for that act, the government made it very clear that it considered these types of activities to be its burden. And with that, the IRS started ruling on RIOs and HINs and HEs, health information exchanges, that they were tax exempt as well. So RIOs, again, which are somewhat like ACOs, were found to be exempt under a lessening the burdens of government theory. I have IRS Notice 2011-20. We're going to talk about that in a little bit. But basically what that notice said is that with respect to MSSP ACOs, Medicare ACOs, as long as you satisfy the CMF safe harbors, they are expected to qualify under a lessening the burdens of government rationale. It also requires, the IRS requires that 5 specific factors be satisfied. We're going to touch on those a little bit later on in the presentation. But again, in the IRS Notice 2011-20, it was stated that Medicare MSSPs and Medicare ACOs can qualify for exemption on that basis. Medicaid ACOs, very quickly, a third theory of exemption for these types of organizations is relief of the poor. And the basis for that is from a 1956 revenue ruling, which prior to that 1969 revenue ruling was actually the original basis for hospitals. And that says that basically as long as you are promoting health for the benefit of the community to the extent of your financial ability, you can be exempt for relieving the poor. In Medicaid HMO context, the IRS for years has been ruling that Medicaid HMOs can qualify for tax-exempt status under this theory. And when we get to IRS Notice 2011-20, the IRS said that Medicaid ACOs could qualify under this basis as well, assuming there was not too much private benefit. So what has the IRS guidance been to date? The first IRS guidance in this area was issued on April 18th, 2011, and it was timed to coincide with the release by CMS of its guidance in this area, the Notice of Proposed Rulemaking. Now note this was different than the RIO situation. In the RIOs, we had CMS telling you what you could do, and the IRS took about 6 to 9 months later. And during that period, again, it was very difficult for tax-exempt hospitals. In some respects, it gave for-profit hospitals a competitive advantage because they don't have to worry about any of this. And so this time around, the IRS and CMS worked well together and released simultaneous guidance, which was extremely helpful to the community. Several months later, when the final rule came out, again, the IRS released its guidance at that point with CMS and provided clarification, confirmation, and actually expanded on its earlier guidance. So again, I think the IRS and CMS did a great job working together and getting this guidance out at the same time, which, having worked for a governmental agency, is not as easy as it sounds to do. So let's look at the first IRS notice, the first notice, and show you kind of the good and the bad associated with it. Well, the good. Well, first of all, the good is that the IRS recognized that tax-exempt organizations could participate in MSSP ACOs, Medicare ACOs, and that they could qualify under a lessening the burdens of government rationale. It recognized that Medicaid ACOs could qualify under a relief of the poor standard, which we just mentioned. And it affirmatively stated that a Medicare ACO's participation, a hospital's participation in an ACO will not affect its exempt status and will not generate unrelated business income, which is what the income that is taxed to tax-exempt organization, if 5 factors are satisfied. And again, I'm holding off on the 5 factors for a little bit. So what was the bad from the notice? The bad was that the notice suggested that all 5 factors had to be satisfied in order for a tax-exempt hospital to participate in an ACO. And the way the factors were drafted, it was going to be very difficult to meet all 5 factors. So already that was a problem. The notice also never stated that an ACO could qualify for exemption by itself. And so it only focused on whether or not you could participate in an ACO. I think the IRS said later that at that point in time, they didn't think anybody would be forming freestanding ACOs that would qualify for exemption, but they've corrected that in the most recent notice, but that was one of the problems. The other difficulty with this notice was that they strongly suggested that if you were not a Medicare ACO or Medicaid ACO, you couldn't qualify for exemption, and in fact, any earnings you got from that organization in which you were participating would be taxable to you as unrelated business income. So taking a giant step back, just because you're a tax-exempt organization doesn't mean all your income is tax-free. There are certain types of income that are taxable to you just like every for-profit corporation, and we call that unrelated business income. Well, what the IRS was saying here is that outside of the Medicare and Medicaid ACO context, your earnings from that organization would likely be unrelated business income, thus making it less attractive for tax-exempt hospitals. So then we fast forward about 9 months, or not quite 9 months, and we get Fact Sheet 2011-11. So what this fact sheet was, and again it was timed with the release of the final rule by CMS, was that it said, well, let me phrase it, they did it in a question and answer format. And so the IRS looked at its earlier guidance, confirmed part of it, expanded part of it, and clarified part of it. So here's the confirmation from the earlier guidance. The IRS said that participation in Medicare and Medicaid ACOs can further exempt purposes. So basically the IRS is saying everything CMS did doesn't affect that. So that's good. It says that the tax-exempt participant share of Medicare and Medicaid ACOs will not be UBTI. Again, that's great. Confirmation, that's still good. It said that Notice 2011-20 remains effective post-CMS final rule. So, again, that's good. We know we can still rely on the old notice. We can look at the new one, but we can still rely on the old notice. I'm going to tell you why that's important in just a little bit. Okay, it also expands on the earlier IRS guidance. It affirmatively states that now Medicare and Medicaid ACOs can qualify for tax-exempt status. And so that's the first time the IRS has really said that. It also softened its stance on commercial ACOs and indicated that under the appropriate circumstances, it may be possible for a commercial ACO to qualify for exemption. And why this is important is because I don't think over time you're going to see pure Medicare ACOs, Medicaid ACOs, and commercial ACOs. It's going to be a mix. And so this gives a little bit of additional support to the tax-exempt hospital to mix up the patients within their ACOs and not have to worry about adverse consequences as a result. The little Qs at the end of that, Q16, Q11 through Q15, those are the questions in the IRS notice that address that particular point, so if you're wondering what those are. It also, again, clarified that Medicare and Medicaid ACOs could participate in non-Medicare, Medicaid ACO type activities without adverse consequences. Now, this is important. Here's where they expand on the prior guidance. What the fact sheet says is that organizations, let me rephrase it, that organizations can rely on what's called the IRS EHR directive. That was that document I told you about that allowed hospitals to participate more fully in RIOs way back when. And what the IRS EHR, which is Electronic Health Records, directive said was that benefits provided by a hospital will not constitute inerrant or impermissible private benefit. Remember, those are the two things we have to avoid. If the benefits fall within applicable HHS regulation safe harbors. Now, why is that important? Because there will be some level of subsidization by the hospitals for most ACOs. Now, in a minute, you're going to hear about the CMS waivers, which are quite broad. So as a tax-exempt hospital, your immediate question is, okay, CMS granted very broad waivers, allowing hospitals to do a lot of things to facilitate the creation of ACOs. What's interesting from the IRS perspective is that nowhere in the fact sheet does it mention the CMS waivers. And so we're left with a little bit of a gray area here. CMS says we can do all sorts of things with respect to physicians, and that's okay from a Stark fraud and abuse type perspective. The IRS has said, you know, we understand the CMS rules out there. You can rely on this earlier guidance, but in that earlier guidance, only a small portion of the physician's costs were being subsidized by the hospital. With the waivers, a much more significant portion of the cost could be subsidized. It would have been nice for the IRS to say, and as long as you comply with the new, CMS safe harbors or CMS waivers, that's okay from a tax-exempt standpoint. So what does that mean? Can you rely on this? Can you provide whatever CMS will let you provide and say that's okay from an IRS standpoint? And I think the answer is no. You can't just assume that merely because CMS allows it, the IRS is also going to allow it under their regulatory scheme. And so what becomes important is that you still have to tailor the subsidization, if you will, that you provide to the formation of an ACO to the actual needs of that community to get it up and running. You can't simply cut a check. You have to do more. You have to simply look at the situation, determine the amounts that you're going to need to provide, document why you have to provide that amount, do a little more effort than just simply say CMS allows it, that's okay. And that's an example I was talking about earlier, where if you just come to the tax lawyer earlier, you can learn that information, and as you're developing the ACO, you can put in to the development process those facts that you were trying to, those results that you were trying to achieve with the ACO, back up while you're providing this type of subsidization, and that can help you at the end of the day. We're going to go through the five-factor. I realize that when a tax lawyer speaks, you usually restart now, isn't it? Okay. There we go. All right. We're going to go very quickly through the five factors because we're very short on time. because I want to get more to the planning size. These are the 5 factors that the IRS says you have to satisfy if you're an ACO. But again, as clarified in the new guidance, you don't have to satisfy all of them. Factor 1, basically that the terms of the shared savings part of this are set forth in advance in writing. And what the most recent IRS guidance noted is that you can set forth the methodology as to how the savings will be shared amongst the participants, and that's fine for this fact. The second fact is that CMS has accepted the ACO into the program. So again, we're just talking about Medicare ACOs in this particular situation. The clarification, and one of the problems that tax-exempt hospitals have is that ACOs are 3 years, or an organization could be terminated from the program, and if that's the case and it's tax-exempt, what happens to the ACO? That factor would imply that it immediately loses exemption, which causes a whole host of problems. And so the IRS clarified that it doesn't necessarily lose its tax-exempt status if the ACO is terminated from the program. Basically, this one just ensures that the economic benefits derived from the ACO are proportional to the benefits realized by the tax-exempt participant. This goes back to our joint venture discussion right off the bat. It has to be fair for the tax-exempt organization. Okay, we're going to skip over the 4th and 5th. Those remained unchanged. Basically, it was that all arrangements have to be for fair market value and that the economic loss borne by the hospital participant couldn't exceed the economic benefits it received. So both of these are on the IRS website. They're easy to find. If you just go to irs.gov and type in ACO, you're going to pull up these 2 fact sheet and notice. They're very short, 5 to 10 pages, very easy to read. So planning considerations. Let's get to this and let's go to questions. First of all, the fact sheet absolutely demonstrates a more flexible IRS. That's great. That can help encourage the facilitation, creation of these types of organizations. The analysis is absolutely a case-by-case basis. There is no uniform guidance out there for ACOs. For standalone exemption, lessening the burdens of government and promotion of health for the benefit of the community, what I've got in parentheses there are the primary support for those types of positions. Very interesting, this private letter ruling, 2044-039. Now, unlike revenue rulings, private letter rulings are not binding precedent. So what a private letter ruling is, if I have a client who wants to go into the IRS and say, we want to do this deal, you got to tell us that it's okay. And the IRS will issue a private letter ruling saying, yes, the way you've described the activity, it's okay. Well, that particular taxpayer can rely on that private letter ruling, but nobody else can. You can look to it for guidance, but you can't march into the IRS and say, you said in this prior PLR that I could do this. The IRS can look at you and say, I don't care if your facts are identical, you can't rely on it. So it's helpful, but you can't hold the IRS to it. Well, the reason that one's important is because if you look at it, and I would encourage you if you're interested in ACOs to look it up, it was an organization set up to take global capitation payments, manage them, and distribute savings to participants. Sounds a lot like an ACO. And so the IRS does at least have one private letter. In fact, I think it's the only private letter ruling out there where there are elements of an ACO in that letter that the IRS has ruled furthers charitable purposes. So again, I think that's required reading for anybody from a tax standpoint. For participation of ACOs through pass-through entities, those are the 2 IRS positions that kind of govern that. We've mentioned earlier that tax planning is usually an afterthought. Entity selection. We're going to go through this rather quickly. When you're forming an ACO, either for standalone exemption or participation in by a tax-exempt organization, you have to decide what type of entity it is. You could form a nonprofit corporation. You could form a limited liability company. You could form a partnership, although most people aren't forming partnerships to do this. Well, the tax results and the issues differ depending upon the type of entity. Skip that and see if we can just get to it. So nonprofit membership corporations. Again, these are not tax exempt. These are just corporations formed under state law. If you set up an ACO as a nonprofit corporation, a lot of PHOs were nonprofit corporations. And so I think a lot of people just knee-jerk reaction try to set them up that way. The problem with this model is that unless the IRS grants that organization exemption, you're conceding taxability of the income of that organization. So you may think you have the greatest argument in the world for exemption, but until the IRS says so, you may not be a tax-exempt organization. And the problem with that is the IRS is currently taking at a minimum 6 to 9 months to determine whether or not an organization is exempt. And if you're an ACO, there's a good chance it's going to be years before the IRS determines that you're tax exempt. So you could be up and running for multiple years thinking you're a tax-exempt organization, and then the IRS decides you're not, and all of a sudden you've been a taxable income during that whole period of time, which can be difficult. There may not be a lot of tax owed, but it wouldn't be an optimum structure. So again, in short, it kind of limits flexibility. It's still a possible model, but it may not be the best. A single-member limited liability company. So again, limited liability companies typically have the advantage of being corporate-like for state law purposes, but being taxed like a partnership. And so there's only one level of tax, unlike a corporation, which typically incurs two levels of tax when it earns it and when it pays it out to the shareholders. So in this case, a single-member LLC might be a good structure, because if an entity owns a single-member LLC, it means the hospital is the only owner. It's completely disregarded for tax purposes. It's treated like a division of the hospital. So during this period of time, you can set up an LLC, you get all the benefits of a corporation from state law, limited liability, et cetera, but you can already start operating as a tax-exempt organization because it's part of you. It's like the hospital is doing the ACO activity. So this is probably a preferable structure in the current time frame until we get more guidance from the IRS. Ultimately, if the IRS grants exemptions, you can flip the LLC and make it taxable as a corporation and get tax-exempt status. So with that, unfortunately, I'm going to have to stop and just take questions. Yes?
Complicated just a little bit.
Mm-hmm.
We know that the docs are running around trying to get money, Mr. Scully pointed
Yes.
out to us. And let's assume they can't attract Scully's deep pockets.
Mm-hmm.
They're in the rural part of Virginia. They need to raise money in order to be able to sell their ACO.
Mm-hmm.
They want to go to a not-for-profit, use a community foundation, a
Mhm.
conversion foundation, whatever.
Yep.
They say, we need X, Y, Z millions of dollars for this, and they want to do it.
Mm-hmm.
Let's say they form an LLC with maybe different tranches,
Mhm.
it's multiple members, for-profit guys and a not-for-profit foundation. If the not-for-profit foundation receives distributions from the business venture, to what level and degree are they taxed?
Okay, that's got 8,000 issues in it. All great question. First of all, let me confirm that the community foundation in that situation does have the ability to make grants to organizations, whether or not they're tax exempt or not.
As long as it's a program-related.
Correct, as long as it's it could be a program-related investment. It could be a grant for charitable purposes. You could demonstrate that that contribution satisfies all that. So that part's all fine. So then you have to look at the return, and the answer is, how is that return earned? In that structure, I wouldn't necessarily recommend an LLC structure. The LLC structure, when you are a tax-exempt organization and you own an interest in a pass-through entity, such as an LLC is by default, the IRS attributes the activities of that organization to you as if you were conducting it yourself. And so in that particular case, if you are, and without getting too complicated, there are different types of community foundations and they're private foundations, you are treated as operating that activity. And so it's not a question necessarily of how you treat the income, it's whether or not the activities of the LLC would affect your tax-exempt status to begin with. If the income comes up in the form of dividends, interest, perhaps they loan the money as opposed to making a capital contribution. Correct, all those, then it generally would not be subject to tax because it would be carved out of unrelated business income tax by the exceptions that are contained in the code. So I think, it's depending upon how it's structured. If it's a nonprofit corporation that's doing it, I think they could make a grant to it with certain conditions. If it's a pass-through entity, probably want to find a vehicle, another vehicle, line of credit, loan, some other way to get the funds to them that might. Depending upon, I'd like to see what the LLC does and what the operating income is, but it would vary. Most of the time, it would probably be more in the loan-type program-related investment. Thank you. I'll hang around as well since we're running a little late if anybody has questions but doesn't want to ask. So, all right. Well, thank you all very much. Thank you, Evan. Thank you.
Quick announcement, there are current copies of our journal outside, and there's a sign-up sheet to receive the symposium edition. One of the articles does talk a lot about what Tom Scully was talking about, physician decision-making and incentivizing that. And so if you are interested in getting a copy of that, you can sign up for it outside. So now we're going to take a short break. There's a light lunch and refreshments. And hopefully you have a chance to talk to Mr. Luthien if you have any additional questions. And we'll be returning for the afternoon session at about noon, so be ready to come back in at that point, please. We'll be talking about FTC antitrust stuff at that point, which I think will be very interesting for many people. Yes?
What's your email address so we can request copies of the PowerPoint?
Yeah, sure. I'll come and give it to you right now. And anybody else can come and speak with me, and I'll give you my email. It was, yeah, it really was. You know, and if you think about it, I think you really it was very, thanks very much. Oh, no, it's not a lifelong problem. We were just talking to address a lot of Steve, my dad, as well. So, yeah, I mean, I really thought this was something very relevant. Set the issues for some. No, that's a good thing. That's a good thing. That's a good thing, yeah. Oh, is he changing stuff up?
He's just writing some notes.
Oh, thanks, yeah. Oh, okay.
all these cases are supposed to go before VAR on eligibility. First of all, providers have appealed it through this separate family system, and the final decisions that were adhered to by the agency. But moreover, there's not a single case of VAR. And we don't want to go, the reason that we didn't pursue the VAR is we didn't want the district coming in and saying, wait a second, there was a right of appeal on the eligibility side, or the medical necessity side, through the family health services, and now you're here on the recoupments. The recoupments are going forward because those decisions are final and we will appeal them. So we were sort of caught, because the beneficiaries were going forward. They have no skin in the game. So anyways, and that's a real thorny issue, I think, and I don't know whether it's ever going to get finally resolved or not. Cheryl's been really very good to deal with over the years, and so usually you can get some kind of equitable resolution of it. But if the district really forced it, then it would have this weird situations going where you might have somebody who didn't have the right option of appeal. Although I think in the end, probably the appeal is you get recouped against or you don't get paid, and take your appeal to the jail on payment grounds rather than necessity grounds. And then you spend all the time telling you why there's necessity. You know, even the medical necessity issues should still be resolved in this, because we've been getting a lot of those lately.
says the new tape is in there and ready to go. New tape's done.
And that should be still stream or capturing?
Yes, it's running. So you're on the capture. It's on mine, probably on that mic.
Yeah.
I'll see if I can find it.
you know they're both in the library?
No, they just came back, they don't have my computer.
Okay.
I'll tell them that there are reserved seats there.
So we got, have they changed their PowerPoint at all? Because if they have, then we're going to need to,
No, but can you help me out just for a few minutes longer?
yeah, what do you
I need you to take
throw these?
these. Okay, I just need to talk this out, I'm sorry.
Okay.
Lerner DeSanti Luthean, I want to give her a little bit more room.
Well, no, Barson.
Anna's gone?
She did?
This is all gone, so it looks like she left, they took this down.
Oh, well, yeah, I don't know, yeah, maybe.
So, are you gonna sit in here, or are you gonna be out there?
I'm going to sit out there, but I might float in and out.
Okay. I don't think I need you anymore. I think that, are there any speakers that are left over from the last meal that are going to stay here?
No, I think they all left.
Okay. So then I can take off these reserved?
Yeah. You can leave that one for the hearing impaired one.
Thank you.
Sure. Second.
Sorry, I didn't mean to preside or interrupt.
No, not at all.
have is this gadget here. I'll bring it to you. And this is the little thing inside. Push it down. It changes the slide. Now you just roll it like that. Like that.
Okay, so I don't have to make it click.
We can try it if you'd like. Yeah, let's just see. Oh, they don't have this up.
That's all right. Well, I mean, you're gonna have to get it up anyway, so.
Yeah, where's my AV? Hello, can we ask you a question?
Yeah, sure.
We want to get this up and just test it quickly. Okay.
Whatever you see happen there is going to happen on the screen.
Okay,
So
so
we
we're
need
just testing the remote.
Okay, well, you got to get it in the screen show mode,
Okay.
and we can do that by going like this.
Perfect.
And now you can try the wheel,
Okay,
Is that good?
up or down.
fantastic, got it.
Perfect?
Yeah,
Okay, I'm going to keep yours up then.
okay.
And then I'll move to Mr. Lerner's as soon as you're finished. Okay?
Very good. Gave you extra tape if you need it. I didn't need it.
The real problem is it's 45 minutes. So much wasted tape. Go ahead.
Yeah, please.
Oh. That's a good one. Sorry.
I wasn't. I wasn't.
Well, I'm trying to think that when we get to the part where we're answering questions, we should both be standing up there, or unless this thing is mine.
It's not mine now.
All right, we'll just both stand.
So, okay. I'll give you 5 minutes, 5-minute warning, but that's just for your lecture, and then 10 minutes after that. One time runs out for Q&A. Yeah, and then we'll have approximately, and then 10 for Q&A. So the 5 doesn't make it 5 left. Yeah. 5-0. Perfect. Great.
We're going to go ahead and get started. Welcome back, everybody. Thank you so much for being here this afternoon. It means a great deal to myself and to the Journal that you're here for the symposium. We have a wonderful afternoon ahead of us, which will be filled with presentations from distinguished experts in the health law field. In the first segment, we will hear from Ms. Susan DeSanti and Mr. Arthur Lerner, who will provide us with an overview of antitrust regulatory issues and government guidance for prospective accountable care organizations. The presenters will take questions from the audience at the conclusion of both of their talks. And I'm going to first introduce you to Ms. DeSanti. She is currently the Director of the Office and Policy Planning at the Federal Trade Commission, a position that she previously held from 1995 to 2001. Currently, Ms. DeSanti is working to implement antitrust guidance for healthcare delivery systems that wish to become accountable care organizations under the Affordable Care Act. In addition to her government service, Ms. DeSanti was both a partner at Shawn & Shine, Nath & Rosenthal and Hogan & Hartson, which is now Hogan Lovells. Mr. Lerner is currently a partner of Kroll & Mooring here in Washington, D.C. From 1982 to 1985, Mr. Lerner directed the Federal Trade Commission Healthcare Antitrust Program. Mr. Lerner also served as attorney advisor to the chairman of the commission, assistant to the director of the Bureau of Competition, and an FTC trial attorney in healthcare and antitrust. Mr. Lerner has been recognized by Best Lawyers in America for his work in healthcare and antitrust. The National Law Journal has named him one of the top 25 managed care attorneys, and Chambers USA has listed him as a top lawyer in the healthcare field. Please welcome first Ms. Susan DeSanti.
Thank you very much. I'm delighted to be here today. I'm going to talk about what the antitrust agencies, the federal antitrust agencies did in relation to the Accountable Care Organization program, the Medicare Shared Savings Program. Basically, at the same time, Center for Medicare and Medicaid Services issued their regulations implementing the Affordable Care Act, the antitrust agencies issued a statement of antitrust enforcement policy for ACOs participating in the Medicare Shared Savings Program. Now, my goals today are to tell you a little bit about why antitrust agencies care about ACOs. I want to outline one of the major provisions. I want to show you how the goals of the law align with the goals of antitrust law. And I want to describe coordination among federal agencies. And I always have to note the views I express are my own and do not necessarily reflect those of the Commission or any individual commissioner. So, what matters to antitrust law? Well, the basic assumption of antitrust law is that competition is going to produce the levels of prices, output, and innovation most likely to benefit consumers. but that also that businesses can take steps to interfere with that competition through anti-competitive conduct, and that would harm consumers. There are two basic concerns behind antitrust law, and it gets much more complicated and fascinating than this. But the basic concerns are, one, price fixing, competitors getting together to fix prices, and two, market power. Okay, let's see. All right, ACOs raise potentially both of these concerns. In the context of price fixing, the question is the ACO just a means for the healthcare providers to get together and fix prices, but not to generate any improved quality or lowered costs? And to determine whether they're just a price-fixing organization or something more, we look at whether they're an integrated joint venture that has the potential to improve quality and lower costs. In terms of market power, we ask, will the ACO enable the providers jointly to increase their market power, i.e., their ability to raise prices, reduce output, or lessen innovation? So how does that antitrust analysis go? Price fixing is automatically prohibited. The courts have long ruled that it has no redeeming virtues. It cannot be justified. It is per se illegal. So, therefore, it is to be avoided at all costs. Integration with a valid purpose, I will speak about how to show that in a moment, but basically, if the ACO can show it's integrated and the integration has a valid purpose, then the ACO is going to qualify for what we call rule of reason analysis, and that enables us to look at both what are the likely anti-competitive effects, but also what are the potential good things, lowering costs, improving quality, efficiencies, that may come out of the ACO. Okay, here's where we start to see the similarities between the Affordable Care Act and the goals of antitrust. In antitrust, we ask about a valid purpose for a healthcare collaboration. Is it designed to improve the quality and likely to lower the cost of healthcare? Similarly, the Affordable Care Act asks, if the ACO meets certain quality performance standards and lowers costs, then if that's the case, the ACO may share in a portion of the savings it has created. Okay, types of integration. One type is financial risk sharing. And let me give you an example. Blue Cross and Blue Shield of Massachusetts has a program where they're working with some ACO-like organizations, whether they're called ACOs or not, where they do a kind of global budgeting, and they give them a budget within which to treat the patients for which they are responsible under that health plan during the year. And it's usually a per member, per month kind of allowance. The healthcare providers then have the responsibility to manage that care so that they stay within that budget and that they maintain quality standards that the insurer also has given them. You have to meet these quality measures as well. All of those providers working together to stay within that budget are at risk for losing money if they don't stay within the budget. They are sharing financial risk. Antitrust thinks that that's a pretty good motivator, and it automatically qualifies for rule of reason treatment if you are financially integrated. Clinical integration, on the other hand, is more complicated. The FTC and DOJ have described it as an active and ongoing program to evaluate and modify practice patterns by the network's physician participants and create a high degree of interdependence and cooperation among the participants to control costs and ensure quality. Now, we don't have regulations that say how you're supposed to be clinically integrated, This typically requires a case-by-case analysis, and there are two reasons for that. One is antitrust is always looking at particular conduct and deciding whether to bring a case, so we're always doing case-by-case analyses. The other reason here is that we don't consider ourselves to be doctors or some kind of de facto healthcare provider. We would rather have, and it's been our policy to have, healthcare providers come in and tell us how they want to clinically integrate, and then we see whether we agree that that's likely to lower costs and improve quality. Now, and there's also an important note here that will tie to something that Art will probably address shortly, which is there's no pre-review. In other words, an ACO can just go ahead and set itself not in the Medicare Shared Savings Program, but outside of that, any collaboration of healthcare providers can go ahead and set itself up. They don't have to come to the antitrust agencies first. They can, if they want to, get an opinion. Okay, what does the Affordable Care Act say about integration? The statute says that the ACO must coordinate care among providers, promote evidence-based medicine, report on quality and cost measures, and promote patient engagement. And to do this, the ACO must have certain governance and leadership structures and use certain clinical and administrative processes. So these are similar factors to the indicia that the antitrust agencies look at to see whether there is, in fact, clinical integration. However, now we have a potential conflict. We've got, on the one hand, antitrust does this case-by-case factual analysis. On the other hand, CMS is going to issue regulations to implement these statutory requirements. So what are we going to do? Well, does it matter? Well, yes, it does matter, because that finding of clinical integration will allow an ACO to avoid condemnation as a per se illegal price-fixing mechanism. Now, some of you who have been thinking ahead of this presentation are thinking, why is she talking about price fixing? Aren't those ACOs in the Medicare Shared Savings Program going to be paid regulated prices, fee-for-service prices? Yes, they are. But many ACOs, and this was obvious to us at the beginning of this process, many ACOs apparently also want to serve commercially insured patients. And in the commercial market, of course, price fixing is illegal. So if an ACO then negotiates on behalf of its providers with an insurance plan, if it's not financially or clinically integrated, then it is potentially per se illegal. So not unreasonably, ACOs wanted some kind of reassurance about if they set up operations in one kind of way to meet CMS's requirements under the Affordable Care Act, will we consider those requirements sufficient in the private market as well? So how did we go about doing this? The FTC and the Antitrust Division of the Department of Justice, which is the other antitrust agency, consulted with each other about the antitrust clinical integration requirements, the kind of regulations CMS was thinking about, and in the end, CMS adopted regulations that they believed satisfied the statute and that we believed were consistent with the kinds of criteria that we look for in determining clinical integration. And CMS's final regulations included a statement that they don't see how ACO participants and ACO provider suppliers could achieve the statutory goals of the Shared Savings Program without showing a degree of interaction and interdependence such that they provide high quality and efficient service delivery. And you may recognize that that's very similar to the language I just read earlier that comes from the antitrust statements. So, now the antitrust agencies agreed that the eligibility criteria CMS came up with were broadly consistent with those of the antitrust agencies, but there was one more factor that was very important to the antitrust agencies in this analysis, and that is that under the Affordable Care Act, CMS is going to be collecting data on cost, utilization, and quality. And so we will finally get some indication of whether these healthcare collaborations, in fact, are improving quality and lowering costs. And as a result, those data will help us see whether, okay, these criteria that everybody has agreed on in the regulations, are they really working? Are those the right criteria for what you need to do to be clinically integrated in a way that will improve quality and lower costs? So in light of that, the antitrust agencies decided if an ACO meets CMS's eligibility requirements and is approved to participate in the shared savings program, and the ACO uses the same governance and leadership structures and clinical and administrative processes it uses in the shared savings program to serve patients in the commercial markets, then joint price negotiations with commercial insurers will be evaluated under the rule of reason. Now, there are more provisions in the antitrust policy statement that deal with market power that Art is going to be discussing. So I'm going to skip over that and just finish with the highlights here. There was an unusual degree of coordination among federal agencies to develop regulations that satisfied one statute and also simultaneously would satisfy an antitrust analysis. I'm really not aware of other situations where that's been done. And I think, but all of the agencies involved learned a lot from each other in the course of that. There's also an unusual degree of coordination among federal agencies on an ongoing basis. We're going to be sharing data. CMS is going to share some of the ACO applications with us. That's unusual as well. And finally, it's unusual for the antitrust agencies, when it comes to a substantive antitrust question, not to apply substantive antitrust, a case-by-case analysis. So for those reasons, I think this is a particularly interesting example of the development of antitrust policy. And I'll thank you and turn it over to Art.
Good afternoon, and we're going to take a flyby through healthcare antitrust and do, between Susan and me, about a semester's worth of healthcare antitrust in about 30 minutes. So we're going to fly. So for those of you who are the advanced students, we really do think you should read the FTC and Department of Justice Joint Policy Statement and guidance on ACOs if you really want a fuller dive. And it'll give you a good one. But that's what I would suggest you do if you really want to get more. And I'll see if I can make this thing go. Did it work? Yep. Okay. We're going to fly through some of this because it's material that you've already heard a fair amount about. I'm just going to flag a couple things in here, which is originally the Department of Health and Human Services had said if you want to get approved to be an ACO in the shared savings program, you're going to need to put yourself through a antitrust screening mechanism in advance. If you don't, we won't, you'll either have to screen yourself against certain criteria and basically get yourself approved, but if that doesn't work, you'll need to get an advance okay from the FTC or DOJ, that ran into a firestorm of criticism, and it came back off the table. And so we're left with something that's a more traditional model of interagency decision-making, but still, as Susan said, a rather innovative and groundbreaking approach of the two agencies working together closely on an ongoing basis on the program as it continues. And we'll talk more about that. That includes the data that CMS is going to be sharing with the antitrust agencies on the one hand, and on the other hand, the agencies basically saying, we're going to trust CMS, that if CMS gives the okay to something and says, you're a real joint venture, you're not a cartel, the agencies are going to credit that. So there's the agencies are sharing info with the antitrust agencies, or CMS is sharing information with the antitrust agencies, and the antitrust agencies are saying, we're willing to trust that CMS is not going to bless a bunch of cartels. And so there's a little bit of a sharing there that's pretty innovative. Going the wrong direction. Okay, there we go. The guidance that's key to understand, the FTC DOJ guidance, it really wouldn't have been very all that important if people want to put together something that they're going to use only for the Medicare program, and the Medicare program only has to do business with them if the Medicare program wants to. There's really not a really huge antitrust issue relative to the way ACOs interface with Medicare itself. The issue was that a lot of the provider community felt that if we're going to get involved in the Medicare ACO program, we're going to want to get involved in commercial activities as well. And we're going to talk a little bit more about that in a minute. And so the guidance really focuses on what happens when these, for the most part, it's really focusing on what happens when these ACOs then try to carry over their activities into the private sector and not just from the Medicare program. Susan already covered this, the whole question. As she pointed out, price fixing is per se illegal. It means it's always illegal. Providers, gas stations, drug manufacturers, steel companies, you're not allowed to fix prices, period. There are no exceptions, except when there's an exception. Okay, so that's what the lawyers get paid for. So the basic notion here is that clinical integration, financial integration, and other bona fide joint venture activities take activity that would otherwise be a naked cartel, it would otherwise just be plain old price fixing, and turn it into something else, where the price fixing is not price fixing, it's incidental to and a necessary aspect of doing something good. And that's this whole clinical integration debate is really all about that. So we have this new safety zone that the FTC has created that basically says we will tell you ahead of time, if you want to bother to come in and ask, that you're okay. Not only are you clinically integrated, which takes you out of the per se rule, but the provider community is worried that it's not just the per se rule, because getting outside the per se rule just puts you into the rule of reason. It puts you into the gray zone, where you then have to say, well, it depends. It depends on the facts. You have to hire lawyers. You have to hire economists. You have to figure out what the market share is. You have to figure out the market share. You have to figure out what the market definition is. What's the product market? What's the geographic market? So the FTC came up with a new safety zone here, and we're going to try to talk a little bit more about it in our remaining minutes, which says you don't have to figure out what the product market is. You don't have to figure out what the geographic market is. You don't have to make judgment calls and worry about whether you got it right or not. The provider community had been asking for more guidance. It wanted more certainty. So they've been given a formula now that says all you need now is a calculator and a lot of data. And if you have a good statistician, you can figure all this out, and you don't need a lawyer or an economist. But as we're going to discuss, it's a little bit different. But basically what you end up having to do is you have to take for every independent ACO participant, and that means each medical practice that's a separate practice, for example, each hospital, each outpatient facility. And on this, I'm going to fault the FTC for giving a slightly over-optimistic sense of a typical calculation you have to do. In the example that they give, they say, this isn't so hard, it ain't so hard. You just, let's say you had a hospital and two medical groups were putting together one of these things. It shows how you would do it. But if you had a hospital and 100 separate doctors who were doing this, let's follow the formula. Every ACO participant, that would be each doctor or doctor group, you'd have to look to that provider and figure out the area from which that particular provider got 75% of its patients. Now, I said contiguous zip codes. That's not correct. That was in the proposed rule. Out of date on the slide there. The final rule is just the lowest number of zip codes from which a particular provider gets 75% of its patients. You have to go through that for every provider for every service they provide. Okay? So if you then figure out the multiplications, that's what you can see why, in order to do this, if you have a lot of individual provider practices in your entity, it's quite an exercise. But if you have a good data set and a good computer, it could all be done, good data, good computer, you can probably run it pretty quickly. But what's interesting about this is it's an attempt to quantify and smooth out all of the rough edges of antitrust analysis, which always are about, it depends, market power, and all these things. This is an attempt to sort of try to crystallize it numerically, knowing that it is inherently, in most situations, going to be somewhat overbroad or somewhat under-inclusive, by definition, because antitrust is a more refined analysis. So it's basically saying, well, if you want to use this ploy, it's a safe harbor, but you could use the more traditional guidance if you want. Then they have various exceptions and provisions of it, and frankly, for today's purposes, since there's no quiz, I'm not going to even bother going through all of the details of it. You can read the guidelines and read the safety zone, and you'll see what they actually are. What's interesting, though, is that the agencies have flagged 4 particular types of behavior for ACOs that are outside the safety zone. In other words, their numbers are too big to be in the safety zone. That doesn't mean they're breaking the law just by being what they are. But when you then get into outside the safety zone, you're then back into the rule of reason, it depends country. The FTC and the DOJ have flagged a number of provisions that they're saying, watch out for these. If you're doing these things, that could drag you down a bit in our assessment of you. And those include some tactics that some more dominant healthcare systems have been using in recent years, which, if carried over into the ACO context, could dampen competition. They're not necessarily always bad, but they're sort of risk flags. I particularly like to focus on the last one, which is when the provider network dictates as a contractual term with the insurance company, thou shalt not disseminate any information on the costs or efficiency or quality of my services to consumers, which is a way of dampening the ability of health plans to engage consumers in making competitive choices among providers if the providers basically prohibit the insurance carriers from generating data that could be shared with consumers to use in helping them to choose. And then other more traditional restrictions on tying and bundling and other things which are sort of can be in some cases exercises of market power. So they flag these as things to watch out for. The agencies are going to have this expedited review process. And they'll give an advisory opinion to people who want one, though people don't have to ask one. This is a little bit more detail on how you'd go about doing those calculations. I wanted to share a couple thoughts, though, with you. I've got a few minutes left. Yeah. A couple thoughts to you about what's interesting about this whole thing. Since, we could talk about the minutiae of the safety zones and of the policy statement, there's some very interesting things about this whole process that's gone on here for students and scholars and people interested in this whole field and what's going on. First, I think the ACO evolution of the way the regs developed, both at the CMS and at the antitrust agencies, is a really good window into the intersection of law, policy, and advocacy in Washington, D.C., and how it all works. Just tracking it all, reading the pronouncements leading up to the passage of the legislation, and then the agencies developing the concept of ACOs and the proposed rules and the final rules. It's a fascinating lineage or line that you go through. ACOs are an attempt in the Medicare program to bring sort of outcome, to make outcomes and incentives and bring that into the fee-for-service side of Medicare. We've always had Medicare Advantage programs, the Medicare HMO and Medicare PPO type programs, but then in traditional Medicare, it was just straight fee-for-service. This now brings bonuses and incentives into the traditional Medicare world. Well, that's been going on in the commercial world for 30 years. for 30 years. And there has been plenty of antitrust guidance around what are the rules associated with provider networks, networks of physicians and hospitals working together to participate in health plans with insurance companies. That's not new. That's been going on for many, many years. There is probably more antitrust guidance that the agencies have put out on that topic over the years in the form of advisory opinions, policy statements, and other guidance and law enforcement than on any other topic of antitrust law combined. I think if you took the number of advisory opinions on that subject and took all of the other advisory opinions and added them up, there'd be more antitrust guidance on this one topic. The provider community was insistent, though, that it wanted more guidance and more certainty. What they really wanted, in some respects, is not more guidance, but different guidance. They wanted the agencies to change the rules and to relax the rules and not just give more guidance. The agencies, of course, absent pressure from Congress or absent some epiphany, were not going to change the rules of what good antitrust enforcement is unless they thought for some reason there's a reason to change fundamental underlying antitrust principles, which they didn't think there was. So they did respond to the desire for more certainty by coming up with this formula that says you want certainty, you can have a safety zone if you go through all these calculations. And then, of course, anytime you give a safety zone, you have to squish it down to make sure you're not giving a blessing to things that have popped out the wrong side. So that was an innovation. Did they really make it more lenient? Some people think maybe they did a little because there's one of the finer points is, whether a certain statistic in the formulation should be 30% or 20%, and they changed a few things there. There's really no way to know whether they actually made it more lenient until we see some years go by and we see some people put themselves through this safety zone formula and see what it actually ends up blessing, because we don't really know that yet. The other thing about it was the agencies actually cooperating together in this way. When I started at the Federal Trade Commission in 1976, if we went over to what was then HEW, I believe, and wanted to talk to them about competition in healthcare, they didn't even know what the word meant. Okay, so competition, healthcare, that was the days when we had the health planning laws at the federal level, which was sort of anti-competition in some ways. And so the notion that HS and CMS and the antitrust agencies would actually be working together to accomplish something together from an antitrust policy and consumer choice policy and healthcare efficiency standpoint is actually rather a good thing, I think. We've talked about the notion that this is makes some business for statisticians, maybe, instead of lawyers and economists. So I think that's an interesting aspect of this. And I think it's also interesting the way they have pointed out some factors that we're looking to, sort of conduct-related factors that are clues to some of the enforcement that we might see from the agencies coming up. But with that, I will stop, and I think we have left some time for questions. Susan, you want to join me up here? So we'll be jointly humiliated if nobody has any questions. We'll be both standing here together with no questions. That's right. That's right. Yes, go ahead.
Most individual medical providers have just a little good to say about insurance companies, particularly the rates that they charge and things like that. To the extent that they join into an ACO, which is now negotiated with an insurance company, is one possible result that the reimbursement rates actually would go higher? And if so, what does that say about cost cut?
Well, I'll take a shot, and then Susan can comment. I think that's a part of focus of what the FTC is basically looking at here. The whole focus of what the FTC and the Department of Justice together were trying to do is to say, if you're pulling yourself together into an ACO because you're going to be offering another choice to the marketplace for payers to look at to see if it actually offers value, offers improvement in quality, better outcomes, lower cost, and allows a better and different way of care being delivered, then that's a good thing. And even if you have to cooperate together and maybe even negotiate price together to make that happen, that's okay. Okay? But if you're pulling together so many providers in a community, depending on the definitions and the statistics, that you're basically putting yourself in a position of being a united front so that the insurance company doesn't have any choice in the matter, and you're not actually having an arm's length negotiation over price. You're actually in a take it or leave it position where the providers have power, market power, and prices go up Well, that's going to flunk the safety zone. It's going to flunk all the guidance that the FTCs of DOJ have given over the years, and you'll have a lawsuit. Now, it doesn't mean they'll catch every one, but in theory, that would be a problem.
It sounds like that the market power, at least if you're from a physician's point, market power is going to stay more with the insurance company. And at least if you're going to generate any savings from this, it might not be, price might be the same, but you're going to have more.
Well, in theory, if it's a smart insurance company, it might be willing to pay a higher price because it's price times utilization times a lot of other things. A payer might be willing to pay a higher unit price if it thought that net it's going to be overall effective. And then, of course, there's nothing to prevent all the doctors from getting together and setting up their own insurance company, too. It's setting up an HMO of their own, and that's all of that.
So what I want to say is that the DOJ is responsible for the antitrust side, doing the health insurers. It's not the FTC. But it's certainly the case that all of this takes place in the context of a health market in which the serious and significant questions have been raised about the market power of healthcare and insurance companies. And on the other hand, there are serious and significant questions being raised about, say, for example, increasing power of hospitals, which are more and more buying up physician practices. There's also a movement in many states by healthcare providers to come up with legislation that would allow them to get together and jointly negotiate price without having to do anything special. And they're seeking to make sure that that legislation is written in such a way that they can qualify for what's called the state action immunity, which basically says state governments, if they're really clear about it and if they really supervise what they're doing, yeah, they can go ahead and decide they want to do anti-competitive things. So there's a much larger context, and Art totally accurately described, sort of the dynamics here of the providers wanting really different guidance.
Yeah, the only other thing I would add is that traditionally in antitrust policy, if you have even if hypothetically you have a monopoly at one end of an equation,
yeah,
it's never been thought that the solution to that is to create a monopoly on the other side of the table. That doesn't actually help consumers. That the solution is to, if there really is a monopoly at the other end of the table, you deal with that monopoly in some way through the public processes of democracy, whatever those are, rather than creating another monopoly. That's not really the way antitrust would view the solution to that problem. Questions? Yeah.
Are you concerned about a thing about the trend of hospitals, companies joining together to become all hospitals in areas being owned by one company so that they're not competing anymore?
The FTC is in the midst of maybe 4 hospital? 3 or 4 hospital merger challenges. It's a big part of what we're looking at. And there are a lot of hospitals seeking to merge. And yes, we are concerned. There's also a background here in that from the late 90s into the early 2000s, the FTC brought a number of challenges to hospital mergers and lost them in courts where judges were convinced that the nice guys at the hospitals really wouldn't raise prices after all, or they were a nonprofit and nonprofits are good. And so there was a whole history. The agency did a hospital merger retrospective under its chairman.
Greatest hits. It was kind of a greatest hits.
Yeah, it is, and it's total soporific for some of you, but it's out of that came a case where we had let a merger go through, and gee whiz, prices went up. We then sued to take the merger apart, and we won, although finding a remedy was practically impossible. I mean, it's always better to prevent the scrambling of the eggs up front than to try to unscramble the eggs after entities have been merged.
Yeah, and I just spent, I represent a third party who's a witness in one of those cases. There's like 3 or 4 of them going on. Some of them are at the appeal stage, some of them are at the earlier stage. There are different stages, but there's 4 cases going on, not just investigations, actual litigations going on right now involving hospital mergers. The one I was at was in Rockford, Illinois, where there's a community with basically 3 hospitals, 2 of them are merging, and it raises some very classic antitrust issues about what happens when you go from 3 to 2. Anyway. Other questions? Is that a half a hand? I see it. Someone pointing. Oh, there's the hand. Okay, yes.
For the calculation of the service areas, statistical calculation that you talked about, how I can see the ACO's entities doing that. Obviously, they're going to have to do it. What about just the independent physicians in the area, or the small practices that are interested in joining ACOs? How would you recommend they tackle that issue so that they know their own marketability in the market and what their impact's going to be?
Before this policy statement came out, the law was the law. And if you were wanting to form some integrated network or be part of a PPO or an IPA or a integrated delivery network or whatever the PHO or whatever the acronym was, you could look at all the guidance that the agencies have put out. If you felt it was necessary, you could hire a qualified counselor, and you could say, this looks fine. This looks fine. And in most cases, the answer is, this looks fine. In a few cases, it's, oh, you got to be kidding. You can't do that. And then in some, it's sort of in the middle. There's really no reason to mess with that whole formula unless you really, really, really need the certainty. So I wouldn't necessarily go off and going through that calculation. I mean, it's really only, in fact, frankly, it's only directly relevant if you are an ACO that's gotten approved by the Medicare program. If for other plans, it's technically not applicable, although you could sort of look at it as being informative guidance. I would say one thing. The advice that, as a lawyer, you get sometimes is providers will come to you and say, one of 2 things, which are bad. How much of this integration stuff do I have to do so I can fix prices? Okay? Which, if you remember what I said about the rule of reason, which is if the price fixing is incidental to the pro-competitive legitimate joint venture, then the price fixing is okay. But if the question is posed, I want to fix prices, how much of this other stuff do I have to do? Makes it very difficult for the counselor to advise the client. Similarly, if the answer is, how big am I allowed to get so I'm not going to get caught? Right? So the key is, what are you actually trying to do? Are you actually trying to do what this is all about, or are you trying to wangle a few more bucks out of consumers? And that's the question that most lawyers are going to actually ask you before you actually have to go through. You know, it's only really people who sort of are saying, well, I need to go get a bank loan, and the bank, you know, is making me go through this. Yeah. You know, some third party is making me go get this advisory opinion or something, so, or go through this whole analysis. It's probably, in many cases, not really necessary.
Yes?
Yes. We're beginning the authorization appropriation process for fiscal year 2013. In light of all the statements about severe budget cutbacks, is there a risk that the administration and the enforcement of this program might be impinged?
I was just at a meeting of all the senior staff at the FTC yesterday, and the first topic and a large portion of the time was taken up with how can we use our resources more efficiently, because we're not expecting that we're going to get any more resources, and right now we're operating on a budget that was last year's budget, which necessarily means that you're already behind inflation, and we're anticipating that we could lose more people. We're doing our very best to make sure that there is still strong enforcement, and I think so far we're succeeding. Is it difficult? Yeah, it's difficult.
Were you asking about the FTC and DOJ enforcement, or were you talking about whether there'd be funding available to CMS to actually?
Both. I mean, it's cutting across all agencies.
Yeah. Frankly, I think Susan and I would both stay in our antitrust zone and not choose to comment on HHS's budget, which we don't know anything about. But maybe some of this, who's on next? Well, so I think your next speaker might be able to, he works at HHS, maybe he could answer that one. So, yeah. Okay, well, we thank you very much. Thank you.
Thank you again, Ms. DeSanti and Mr. Lerner. I want to offer a quick apology. Apparently, Windows is really pesky with updating and having to restart the computer. So I'm going to make sure that that doesn't happen during your presentation. I next have the pleasure of introducing another expert in the health law field, Mr. Troy Barsky. Mr. Barsky will be discussing fraud and abuse law waivers. He is currently the director of the Division of Technical Payment Policy in the Center for Medicare at the Center for Medicare and Medicaid Services. Mr. Barsky's division focuses on technical payment issues related to fee-for-services Medicare. He is responsible for policy development related to physician self-referral law and has been a part of the CMS team for developing the Medicare Shared Savings Program and accountable care organizations. Previously, Mr. Barsky served in the Health and Human Services Office of the General Counsel CMS Program Integrity Group. In that role, he focused on Medicare and Medicaid fraud and abuse. Please welcome Mr. Barsky.
Okay, great. Well, thank you very much for the introduction and for inviting me here today. So I'm going to talk, and also thank you for sticking around at the last session for today. I'll try to keep this as least technical as possible. Unfortunately, with these fraud and abuse laws, if you are familiar with them, they do get a little technical in nature, but I'll do my best to keep it big picture. I'm going to talk about a few things today. First, I think we've been talking about the Shared Savings Program, the Pioneer Program generally today. I'll spend a minute or two just highlighting a few important topics related to those programs. Then I'm going to just give a very short primer on the fraud and abuse laws for those of you who aren't familiar with them. I think it's important to understand what we did with regard to the waivers to really understand what these fraud and abuse laws are all about. Then I'm going to explain the waiver and get into some detail about what we actually did with the waiver, and I think it's sort of similar to the other speakers have been talking today about sort of innovative work of the government. I think really what we did here was rather groundbreaking in terms of our history in terms of dealing with these fraud and abuse laws. And then we did issue an interim final rule with comment a few months ago, and we did receive comments recently. So I'll just give a few thoughts about some of the comments that we received related to that rule. So why don't we just jump right in? Okay, great. So a lot of this you've already heard about the shared savings program. I think one important point to mention is that, and I think it's been mentioned earlier, is that this is a fee-for-service program. So a lot of the fraud and abuse laws that are in place now really deal with the fee-for-service system where there's incentive to overutilize, and in some cases, if you're going to work on limiting care, incentivize to limit care, which is what ACOs are all about, or at least partially about. There's also the incentive to underutilize care. So these are what these fraud and abuse laws were designed for. But also these fraud and abuse laws are still in effect. We don't have a capitated system. We don't have a Medicare Advantage system where a lot of these fraud and abuse laws may not be as relevant. The main purpose of the law, and I think the takeaway purpose of the law is to integrate providers, both financially and clinically, and this becomes important when we start to think about the real purpose of the fraud and abuse laws and how there's a real tension between what we're trying to do with ACOs and historically what we've done with these fraud and abuse laws. Oh, great. So eligibility, and this is probably another topic that was covered earlier, but I just wanted to touch briefly on the shared savings program, that there are certain types of providers, groups of providers that are eligible or could be eligible to enter into the shared savings program. And listed them here. It could be ACO professionals in group practice arrangements, networks of individual practices, hospitals and group practices entering into a joint venture, or hospitals also employing ACO professionals, also rural health clinics, federally qualified health centers, and certain critical access hospitals, and also other providers aligning with some of these other entities that I just mentioned. Now, all of these types of entities, and why it's important, I think, to focus on this, is that all of these entities create new financial arrangements or new financial relationships which trigger the application of these fraud and abuse laws. So for us, it was very important to understand and to really think about, on the fraud and abuse side, what kind of relationships providers and suppliers are going to enter into when they're creating and developing an accountable care organization. So the fraud and abuse laws, and let me just spend a few minutes talking about those in particular. What we're talking about are the physician self-referral law, which we're responsible for at the Centers for Medicare and Medicaid Services, also the anti-kickback statute, which is under the jurisdiction of the HHS Office of Inspector General, and also the civil monetary penalty law. In particular, there's gain sharing, which deals with stinting of care, prohibition on hospitals incentivizing physicians to limit care, and also prohibition on inducement to beneficiaries. As we'll talk about, there are incentives within ACOs to induce beneficiary behavior, which could trigger the CMP on beneficiary inducements. Now, before I move on to a little more detail, a lot of folks had, before, when the ACO concept was being thought about, the one issue that was on everyone's mind is, how is this going to work when you have these fraud and abuse laws that are really designed to keep parties apart? As I said, ACOs were really designed to integrate parties, bring them together. The fraud and abuse laws are all about keeping parties apart, keeping them at arm's length. When they have financial ties together, there's an incentive, there's a financial incentive to overutilize services in a fee-for-service system. So how do we deal with that is the topic I'm going to talk about in a few minutes. But let's first explore the fraud and abuse laws a bit. Okay, first the Stark Law, the physician self-referral law. Now this, technically, it prohibits physicians from referring their Medicare patients for certain designated health services like inpatient or outpatient hospital services to entities in which they have a financial relationship. I think the perfect example is a physician who has an ownership interest in a laboratory, that they cannot refer to their own laboratory. Obviously, there's going to be an incentive every time they refer. They're going to gain more profit through their ownership interest in all of those self-referrals. So there are many exceptions, and folks comment that the Stark Law is as many exceptions or as complicated as a tax code, and only took intro to tax in law school, so don't have that much to compare it to. But we do have many both statutory and regulatory exceptions that are in the law, which makes it challenging oftentimes to apply. But I will say that there are certain exceptions that are in existence, such as employment exception or other exceptions, which really allow for a lot of activity to occur that ACOs would want to enter into, such as employment, personal service arrangements, or other type of. We also have an exception for a donation of electronic health records that would be allowed in the ACO context. But we also recognized that they weren't going to cut it, that they weren't going to get us all the way there to the new world of ACOs. Anti-kickback statute. As I said, this is an OIG administered statute. This is an intent-based criminal law that, broadly speaking, prohibits the purposeful buying and selling of any federal health care business. This is broader than the Stark Law. As I said, the Stark Law deals with specific designated health services that are listed in our statute. The anti-kickback statute is broader than that. It is an intent-based statute as opposed to the Stark Law, which is a strict liability statute. So in some there are safe harbors with regard to the anti-kickback statute, which are not mandatory to meet, but they are they do provide some protection for certain arrangements. Now, both of these self-referral laws, both the Stark Law and the anti-kickback statute, were enacted in the context of fee-for-service system that rewards volume over quality. And again, this is something that we really had to think about when we were dealing with the shared savings program. But in contrast, the gain sharing civil monetary penalty law is a little different in that in the other two laws we're dealing with overutilization, now we're dealing with underutilization. It prohibits hospitals for paying physicians to limit care and limit services. There's penalties up to $2,000 per patient for those services, and again, all of these laws were really designed with the mindset that we wanted to remove temptation, financial temptation to physicians to either increase or underutilize services. Beneficiary inducement, civil monetary penalty, as I had mentioned, this also comes up in the accountable care organization context. This is deals with a situation where you're inducing beneficiaries either by giving them free services or discounted services, either in kind or monetary benefit, to encourage them to get certain care. Oftentimes it's unnecessary care, but that question is also raised in the accountable care organization context as ACOs try to affect beneficiary behavior. So now that you understand the big picture with these different laws, hopefully you can see that there's a real tension between the fraud and abuse laws and accountable care organizations. We did try, at least in the world of Stark a few years ago, to actually craft an exception under our law where we tried to allow for certain gain-sharing arrangements, certain type of integrated delivery systems. Unfortunately, under our law, we have a high statutory bar which says that there could be no risk of program or patient abuse. So it was very difficult for us to create a useful exception that would actually allow for full integration in the mindset of what would be considered an ACO or some other kind of integrated delivery system. So we did try that. We proposed a rule a few years ago. We ultimately did not finalize that rule after I think the overwhelming number of negative comments that rule really wouldn't accomplish the goals of full integration. So now we move to the world of the Affordable Care Act, where we're given certain abilities to waive laws where before we needed to create exceptions and safe harbors where we did not have as much flexibility. So before I get to the waivers specifically, I just wanted to also just move to the next slide. Okay. So we worked very closely with the program staff that worked on the shared savings rule itself. And for those of you who may have taken a look at it, it's a very detailed regulation that tracks the statute. We worked closely with that group because we wanted to make sure that if we were waiving these fraud and abuse laws, that we still had significant program and, more importantly, beneficiary protections in the program that would allow us to feel comfortable that even though in the past we had these fraud and abuse laws that protected beneficiaries, now we were going to have the program itself that was going to be incentivizing good care, high quality care, lowering costs, but also beneficiaries getting necessary care that they needed. So we worked to create certain provisions within the regulations that were also contained in the statute, but we really filled in some important details that made us a lot more comfortable, and just wanted to highlight them quickly. First, the governance rules. This is, I think, a real difference, or I know a lot of industry has picked up on this point, that we really required a very strong governing body within the ACO, that they would have a fiduciary duty not simply to a particular provider or a particular physician group, but that they would be responsible for the behavior of the ACO as a whole. And that board needed to be representative of the entire ACO, and they also, as it was talked about earlier, there needs to be at least 75% 75% control by participants of so by participants meaning physicians and hospitals, that you can't have venture capital firms, you can't have insurers coming in, at least in the shared savings program and the Pioneer program, and having them dominate the ACO or being driven by insurance companies. We understand that in the commercial market, there are other ACO-type models that are being driven by insurers, by other entities. But with regard to the shared savings program, we really wanted this to be physician-driven or participant-driven and not being driven by outside parties. And so all of these requirements together, in our view, really changed the structure of a lot of integrated delivery systems where you had a strong governing body not only making decisions but responsible for making decisions, as we'll get to in a few minutes, making important decisions with regard to waiving the fraud and abuse laws. We also required significant transparency and public reporting requirements. There were a lot of provisions in the Affordable Care Act that dealt with creating sunshine in a lot of different areas, such as, one particular example is with drug payments and device payments or payments from device and drug manufacturers. So here as well, we really wanted a lot of transparency to understand how shared savings was going to be used to integrate care and change the delivery of health care. Also, we created very strong auditing and monitoring functions. We built that right into the regulations, and ACOs needed to agree that they were going to abide by those strong monitoring functions. And then finally, that if problems did arise, that we would be able to put them into corrective action plans. And also, we had very strong termination provisions that if things were not going as we wanted them to, if they weren't meeting their quality goals or quality measures, if they weren't reducing costs, that we had the ability to remove them from the program if we saw problems happening. So there were real protections put into the law that made us a lot more comfortable, especially on the law enforcement side. Our colleagues at the Inspector General's office, also coordinating with the Department of Justice on the civil and criminal side, making them more comfortable that we would still have the ability to enforce our fraud and abuse laws if bad things were happening. So getting to the waiver itself, just forward that, yes. Other way. One more. Oh, now it's working. Okay, thanks. So the waiver authority. So as I've been leading up to, the statute gave us the ability to waive fraud and abuse laws, which we proposed a rule. We actually just issued a proposed notice in concurrent with the proposed shared savings rule earlier last year, where we proposed a rather narrow, or I'd say middle-of-the-ground waiver, and we solicited comments to try to see what other waivers were necessary. In our final waiver, we definitely went much broader than what we originally proposed, and we issued that, as I said before, as an interim final rule concurrently with the shared savings program rule. So there are 5 different waivers that we ended up with, and I want to go into a little detail with each of them. First, there was a pre-participation waiver. Many folks in the industry had said to us, we can't get an ACO started unless you allow us to either have hospitals fund certain and have certain kind of contracts, financial arrangements that don't fit in any exception. We need to donate electronic health records or electronic health record systems. We need to integrate our care delivery system. We need to hire new staff. And all of those type of arrangements create new financial relationships that would traditionally trigger our fraud and abuse laws. Also, participation waiver, as you'll see, very similar to the pre-participation waiver. Obviously, as the name implies, once you are an ACO, this waiver would apply to you. Also, the shared savings waiver. Let's say you're an established entity that you don't need to do much different to become an ACO, and you don't really need to jump through a lot of our requirements with regard to the pre-participation or participation waiver. You could just have a waiver for shared savings, and the requirements for that waiver were much less. So we also we proposed that, and we finalized that as well with the ACO program. There's a distribution of shared savings if you achieve quality and cost-saving goals. We obviously knew that was going to create a financial relationship. We needed to waive the laws with regard to that provision, and we felt that the risk of fraud and abuse was, or the benefits outweigh the risk of fraud and abuse in that area. Also, what's different with some of our other waivers in the past is that Traditionally, Medicare would issue waivers like in a public health emergency. We would issue a spot waiver for particular hospitals, like in the context of Hurricane Katrina, where we had to issue waivers of laws for certain hospitals. Here it's different in that we were publishing a waiver, a blanket waiver, that would apply to any ACO or any ACO participant, assuming that they met all of our requirements. They didn't have to apply for a waiver, and they make their own determination as to whether a waiver applies or not. We do have an advisory opinion process, both in the Inspector General's office and also in CMS, where if they had questions as to whether they did or did not fit within the waiver, they could always request an advisory opinion. But we try to add as much detail as possible to avoid that situation so that folks can get started, and ACOs can get started as quickly as possible. Also, as I had mentioned before, but I think it's worth repeating, the waivers don't apply to an ACO, and I think this was it's still a misconception that I think is out there, that an ACO wanted to know, how do I get the waiver? How do we get the waiver? The ACOs don't get the waiver. As I said, it's not an application, but they don't have a waiver that covers the entire ACO. The waiver applies to specific financial transactions that they are entering into, different contractual relationships, different financial arrangements, whether it's exchange of money or it's an in-kind benefit, some non-monetary compensation that's going to create a financial relationship. All of those relationships need to fit within these exceptions, but the ACO as a whole don't get these exceptions. So, next slide. Okay. Great. So before we get into the 5 specific waivers, there's one term that we use throughout our waivers that I think is very important, and this was really a major change from what we had done previously, where, as I mentioned, our exceptions and safe harbors have traditionally been very technical. They have many of them have a requirement that an arrangement be in writing, that it be signed by all parties. Oftentimes you can get tripped up in these fraud and abuse laws if you don't meet all of these requirements. Well, for purposes of these waivers, we did away with those requirements, and instead we looked at trying to get at what the purpose was of parties entering into these arrangements. And we came up with what we felt was a standard that could be applied in a lot of the waivers, was that any particular transaction needed to be approved by the board, and they needed to make a determination that what that transaction was trying to accomplish was that it be, or the action be, reasonably related to the purposes of the shared savings program. And then we outlined specifically what we meant by purposes of the shared savings program, and we really took this directly from the Section 3022 of the Affordable Care Act, or the Shared Savings Program statute. At the very beginning, there's a preamble, or I call it preamble discussion, sort of outlining the purpose of the shared savings program. And if you compare what we ultimately came up with, the purposes of the shared savings program for purposes of the waiver and what's in the statute, it's virtually identical with some slight modification. But essentially, we wanted a board to make a determination that that transaction was going to promote accountability for the quality, cost, and overall care of the Medicare patient population that's in the ACO. Also that they were going to manage and coordinate care for Medicare fee-for-service beneficiaries, and also encourage investment in infrastructure and care redesign to take the money that they were earning through shared savings and bring it back into the ACO in order to encourage further integration and really focus on the patient. So all of these, and as we'll see, this standard is integrated in the what we believe will be the more used waivers. So the pre-participation waiver, as I said, it applies to startup arrangements only. We had a lot of questions as to how broad this would be, and we had contemplated in our solicitation of comments last spring that we were going to sort of define the types of startup arrangements that would be allowed. And as we explored this more, we realized that in order to allow ACOs to be as innovative as possible, it was very difficult to say specifically that these kind of arrangements were okay and these other kind of arrangements weren't. So instead, as I said, we went with this concept of if there are if what the transaction is trying to accomplish is reasonably related to the purposes of the ACO, then that's going to be okay. We did list a very long list in our preamble discussion about what type of arrangements might be pre-participation type transactions. Just I'll give you an example of a few: infrastructure creation and provision of the ACO, care coordination mechanisms that were not in existence, hiring of new staff, as I had mentioned. Now you're going to have to hire care coordinators, and a lot of new staff who wouldn't necessarily be part of a hospital or part of a group practice, but were hired would be hired separately to coordinate across the ACO, also creating new information technology systems. Now, as long as a party was taking diligent steps to bring forth an ACO, bring them into the program, they would qualify for a waiver during that first year time period before they entered into the shared savings program. Also, that we recognize that before an ACO enters the program, they may be trying to bring other parties in. So we at least wanted there to be one ACO entity that we could point to that was sort of driving the train, if you will. And as long as they could point to that one entity, at least to start out with, the waiver could apply to them. And then also, as I mentioned, that the governing body was very important, that you really needed to have some governing body, and that what's defined as a governing body is defined fairly broadly, but there needed to be some decision-making board that would make a determination that what they were doing was reasonably related to the purposes of the ACO. Also, we required that there be documentation of a lot of the decisions that were made and kept for up to 10 years. We tried to limit the burden of actually producing documents to the government, but at least that if we wanted to audit later, we would have an audit trail for us to go back and look to see what happened. Just move to the next slide. Okay, participation waiver. Similar to the pre-participation waiver, it also requires a governing body authorization, and it applies to ACOs who have entered into participation agreement with the government. I'm not going to get into the excruciating details about termination, but we actually got quite a few questions, and not surprisingly, these waivers are very important for ACOs. And folks wanted to know when the waiver started and when the waivers concluded. And especially if, just going back to the pre-participation waiver, if they ended up not going into the program, they wanted to see when their waiver concluded. Also, once they were in the program, but let's say they were in for 3 years and then they terminated at the end, how long would the waivers last for? So we wrote a lot of it's amazing how many different permutations of what might happen as an ACO was a participant in the program, and when they left, what might happen in those different circumstances. So we try to deal with all of those situations. I'm not going to get into those details now, but it was quite challenging to deal with those termination provisions. And often in regulatory drafting, especially in the context of compliance with fraud and abuse laws, that question becomes very important. So we had to deal with that here as well. The shared savings waiver, as I had mentioned earlier, this just deals with the distribution of shared savings payments. It does not have as strict of a requirement dealing with the being reasonably related to the purposes of the ACO, as long as that distribution is happening within the ACO. We try to be very flexible in that we allowed for distributions within the ACO. So if you're a physician within the ACO, you could essentially get as much distribution of shared savings as you wanted. Of course, they still need to comply with the transparency requirements I was talking about earlier, but they still were, they have a lot of flexibility. If there was distributions outside of the ACO, we again wanted to make sure that there were, that it was reasonably related to the purposes of the ACO, so that you weren't, one thing we're really concerned about is that you have physicians who have the waiver inside the ACO and then are trying to have some side business completely unrelated to the ACO. They have a separate MRI center, a separate laboratory, and that they're using the waiver to protect or shield those arrangements that we otherwise wouldn't be comfortable with. So we try to make clear as to wall those type of arrangements off while still allow for beneficial arrangements within the ACO, including in this waiver as well. And the last two waivers, the START compliant waiver is more technical, but essentially the anti-kickback statute, the civil monetary penalty laws don't always line up specifically with the START laws. Our laws are similar, but there are differences between them. So what the OIG said is that if you're compliant with the Stark exception, you'll also comply with the anti-kickback statute, which is helpful in certain circumstances. And then finally, as I talked earlier about beneficiary inducement, we'd said or the OIG said that with regard to beneficiary inducements, that would be okay as long as it was related to medically necessary care. So giving away a monitor, sort of medical monitor, would be okay. Giving free tickets to the opera would be questionable. So we created guidelines with regard to that exception as well, or that waiver as well, just to make clear that there could be legitimate reasons to induce beneficiary behavior. So finally, just talking about the comments that we received. Generally, I think it was mentioned by the last speaker, folks were, I think, quite pleased with the scope and extent of our waivers. We really, I think this was really innovative in regard to the fraud and abuse laws, where we really relaxed them completely, and it sort of we're watching to see what happens, and we're doing a lot of monitoring. We're hopeful that the ACO model will induce or encourage positive behavior, and that the bad behavior that these fraud and abuse laws are meant to stop won't occur in the ACO context. But of course, we're not naive, and we do have strong monitoring in place. We also have these requirements of going through the board. And if we find that shortcuts are taken, that that decisions by the board don't happen, or that there's no determination that this is actually reasonably related to the purposes of the ACO, that everyone just gets some sort of kickback within the context of the ACO, and there's really no benefit to patients, well, then I think we really would have serious concerns as to whether the waiver even applies to them or not. Also, there were questions that we received about, we made some comments at the end that essentially said, we're watching closely and we're taking a chance here, and that if things don't work as we think they are, as we hope they will, then we will tighten these waivers in the future. And so there were questions that perhaps that could lead to some uncertainty in the marketplace. I think from our perspective, as mentioned earlier, we have 32 pioneers that enter the program. We do have a sizable number of folks who have applied for the first round in the shared savings program, which will, the first round's in April, the second round is in July, and we have a lot of interest there, both on the hospital side, and I discussed earlier that all of these are all going to be hospital-driven. I think that at least the initial data we're seeing is that while there are many hospital-based ACOs, there are also many physician group-based ACOs as well that don't have hospitals in them. So I think we're really seeing a lot of variety as well. But there are questions as to how long the law enforcement folks will allow this waiver to go on. So we'll see. I think it's our intention that this program will work, and it's our hope that this will work, and that we will keep these waivers as broad as they are. I guess the last thing I'll say, just interaction with state laws. We've had a lot of requests. There are many fraud and abuse laws at the state level as well. And while we've waived our fraud and abuse laws, the states haven't. So there's been many questions at the state level as to whether whether the federal government preempts state fraud and abuse laws. We haven't taken a position on that now, but it is a question that we've received, and we'll consider that. To date, we haven't stated that there's any preemption, and I think until the agencies say anything further, I think that you do need to also pay attention to your state laws as well as the federal law. And we are aware of certain situations, and we are coordinating with states, obviously, to make this as a successful program as possible. So with that, I'm going to stop and see if there are any questions. I know I'm pretty quickly, but I'm happy to take any questions from anyone. Yeah.
Right now, are waivers only applicable to those who are forming Medicare-related organizations, so like a Medicaid or a private ACO covered by this?
Yes. So the waivers apply in two contexts so far, and it's a good point. It applies in the shared savings program, also applies for the pioneers, which are both Medicare programs. A lot of the concepts that I discussed today could also be applied in the innovation centers, also exploring many other types of models, different state programs, Medicaid programs, other types of programs. So we are considering trying to use these same ideas. I think we did a lot of the hard work, and we're working with the Innovation Center to see how these same concepts would apply to the other models that they're going to test. So yeah, I think it is. So while I was talking about the shared savings program today, I think a lot of these concepts will translate to those other programs, and we coordinate pretty much daily with the Innovation Center and talk to them about the different models that they have up and coming. Other question? Yeah.
To what extent do whistleblowers play in your enforcement program, and do you have any financial incentives like TCAM actions?
Well, it's a good question. I will say that one thing that we've seen already is that we haven't necessarily seen anything in the False Claims Act context. There have been questions, as you could assume, when you have these new federal programs, there's a lot of action in the marketplace. So we've seen from certain competitors of ACOs or folks who are coming together as an ACO, you have these competitors coming to the government saying, hey, this is going on in the marketplace. Are you aware of this? And we're not sure that this even meets the antitrust guidance or that this meets the fraud and abuse law waivers, even if they have a waiver. So obviously those questions, and they haven't reached complaints or there's no investigations going on, but we are aware of a lot of activity in the marketplace, and we are spending a lot of time talking to industry and trying to understand what's going on. And I definitely think that in the future, that if there are certain activities that do occur that fall outside of our waiver, that we will be working closely with law enforcement, whether it's the Inspector General's office or with the Department of Justice to bring those actions forth. But to date, I could only assume that the key TAM, that the relator bar, is just waiting and sort of taking in this whole process, understanding that in some ways these waivers take away a lot of their potential business, and that they bring actions under the Stark Law or under the kickback law, and now it's taken away for purposes of these ACOs. So I think we're exploring, as they are, how this is going to impact the marketplace going forward, and obviously coordinating closely with Department of Justice on the criminal and civil side to see how that carries forward. So I think it's a good question, and one that we're all going to watch in the next year or two and see how that plays out. But I think it's too early to really say right now. So other questions? Okay, great. Well, again, thank you so much for the invitation. I really appreciate it.
Thank you again, Mr. Barsky. Before we conclude, Evan and I would like to thank all of you again for attending, and to all of our speakers who were here today for just a wonderful presentation. We were very fortunate to have you all here. Thank you very much.
Thanks, everybody. It was, we thought it went over very well. Yes? I'll give you my email. I'll come give it to you right now, and I've got all of them, so I can send you everything. Yeah. Okay.
And the symposium edition will be available in the spring. If you haven't already, you can sign up outside, and there's a current copy of our journal issue outside available for your taking. Thank you very much.